Milord, before Milord, in my respectful reply to the query of the Honorable Court, Milord, that violation of principle of natural justice, it is an established settled proposition that one is prejudice theory, Milord, has to be looked into when we are to look into the issue of principle of natural justice violation. And secondly, Milord, is also that when the conclusion is inevitable, it will not make any difference. There also violation of principle of justice cannot be invoked, that why this not given to me, why not that given to me. Inevitable conclusion is what it will be. It is crystal clear from the entire records. So these are the two Milord settled proposition on the issue of violation of principle of natural justice. So here, Milord, before adverting respectfully to your Lordship, Milord, may I refer to certain crucial facts of this matter, Lordship. This gentleman, he was given this lease on 6th February 2018 was the date of registration. So as per Rule 5, 2016 rules, that it has to start, commence from date of registration. Rule 5 of 2016 concession rules. So it expired on 5th February 2023. So this gentleman, he suffered the first show cause notice. One was 26th February 2019. That will appear at page 116 for his illegal mining. He did not wait for writ of possession. He did not wait for demarcation. Started the moment he got the lease deed registered, started his mining activity. So now this gentleman, for the first time he comes before the Honorable Court in the year, Milord, kindly sees the first writ order, that is 139. The first writ order, writ court order, Milord, yes. Page 139, Milord, in Milord, volume Milord 2.
Yes.
Here he comes to challenge, kindly sees one memo that is of July 17, 2019.
July 17.
The first two lines of the order will, Milord, indicate, yes, Lordship. Yes. This will appear from page 127, Milord, of the writ petition. Now here, kindly sees the date 27th April 2021 was the date of passing the order. Milord, he does not come challenging the earlier suspension order, because before that his earlier suspension order was recalled.
Earlier suspension is 26th of February.
2019, recalled on 26th December 2019.
132. Oh, so one was on 26th of February. So another was on July 17, 2019.
That was on a different score. Kindly sees page 127. What was the issue? 127, page 127, volume 1. Kindly sees page, Lordship. May I respectfully invite your Lordship, Milord, to page, Milord, 127, Lord. Volume 1, Milord.
Yes.
This is by DM, Milord.
Yes.
Right. Suspension of sand mining. And it also carries the reference of 26 February 2019. Also, kindly see the reference part.
Yes.
And thereafter, his applications were adverted to several applications by him. Thereafter, replies submitted by you in response to the suspension order, along with show cause notice in connection with illegal sand mining activity in the sand block, code number so and so. An opinion was sought for from the SP so and so, and the suspension order was issued based on the report received from SP. The SP so and so report in this regard, where it opined that the law and order problem may crop up in the zone, the opening of sand block. So revocation suspension cannot be issued from this end until the clearance is so and so. So this is the order which Milord directed that you dispose of this particular petition. Now he comes up with a second writ petition that is very crucial, 167, which my learned friend has already referred to your Lordship.
167.
167. This is the order, Milord, dated 10th February, Milord, 2023.
Yes.
By that time, the lease has already expired, because lease expired on 5th February 2023. So here he comes with twofold prayer, because when this particular writ was preferred, 7th March 2020, order was staring in his face. So he makes an additional prayer before the Honorable Court that in addition to my show cause, I should also be given a liberty to prefer an application for extension of lease for the first time. So after expiry, he comes with this prayer. And thereafter he gets the liberty. So liberty prayed for the first time. Even not before, prior to this prayer before the Honorable Court, even he did not have had any kind of application for extension before expiry, before the authority. So thereafter, upon getting this liberty, he comes with an application. That application is at page 170. This is his first application for extension of interim order, extension of the lease period.
So according to you, the application, if any, for extension has to be prior to its expiry.
Should have been, because after expiry, his entire exercise starts. So first part of his battle was, why suspension? Why not recalling taking place? It should be recalled. Then he comes up with a challenge before this Honorable Court. Before this Honorable Court, his alternative prayer was, liberty may also be given to me to pray for an extension of it, which was, by that time, it has expired. So his main plank is now that extension of lease. So this is then third, fourth, fifth, all this comes up. In this background, my lord, this final order comes from the DM. Now, DM, my lord, if your lordship, if I am respectfully invite your lordship, my lord, to the order impugned, kindly seize.
DM is the appellate authority.
No, DM is no. DM is the forum of first instance. Appellate is, my lord, it is divisional.
Divisional commission. Yes, where is the DM's order?
DM's order is now challenged before your lordship. There was the first DM order.
That has been set aside.
That was
remanded.
That was remanded before the debate.
Please show me the ordering part of the remand order.
Remand order is at, my lord, page 206.
206, yes. Yes.
My lord, the order number 2, 9th June, my lord, 2025 at 206. That is the principal order. And observation, my lord, is at page, my lord, 208, my lord. 208, my lord, on scrutinizing all the relevant documents and materials on record, it is found that the long-term mining lease of the appellant was registered on so-and-so as per so-and-so for 5 years. Therefore, said lease of the appellant valid till 5th April. It appears suspension order 7th March 20 was issued by the DM. It also appears no field inquiries conducted on behalf of the sanctioning authority. It found from the submission of DL LRO, Makura, 12 June 2025, that suspension letter were issued on the basis of report of SP. It was mentioned illegal mining was being carried out by the lessee, but the report does not mention about the field inquiry by the lease sanctioning authority. Further, no hearing or inquiry done on behalf of district authority and no records of seizure was presented. No proceedings or police case seems to have been initiated and followed up. Suspension order seems to have been issued and later withdrawn merely on the basis of police report without having independent inquiry by district authority. No tangible evidence for alleged lapses by appellant is presented. No penalty was imposed upon the appellant for his lapse as alleged. Therefore, under the it is evident suspension order was imposed without having any field inquiry by the lease sanctioning authority. Hence, the instant case is remanded back to the end of the DM to hear afresh and dispose of after giving opportunity of hearing to all the parties concerned and field inquiry by the lease sanctioning authority. So, since appellate authority was not happy with the order of the DM, so it was remanded back. So, my lord, so this authority commissioner wanted a joint inquiry to be held. He also is on the view, yes, I should be very candid, that when he issued this, he was dealing with two show causes, kindly see. With 26 February 2019 at page 208, numerical 1. And also 7 March 20, although it should have been only with respect to 7 March 2020. So, this observation which he says suspension order has been withdrawn, that means he refers to this 2019, yes, not 2020. So, he, sum and substance, yes, sum and substance, he wanted that he should go for a field inquiry. That is in the year 2025 we asked for. So, accordingly, my lord, now if I am respectfully invited, lordship, my lord, to the, my lord, impugned order. That is passed by the DM thereafter. On remand, now he sits on remand. So while sitting on remand, my lord, he passes this order at page 224, which is before your judicial scanner, before your lordship. Now he say, my lord, kindly sees at the very outset at page 224, my lord, on perusal of the written submission from the petitioner. So he is perusing the written submission which has not been annexed to the writ. What was the submission? I'm in the dark. Your memo of appeal is also not annexed. Because principal challenge, what was he placing before the appellate authority? So upon perusing all this,
The appellate authority, this is the original authority.
sorry, Miller, forum of first instance. So he is,
Submission, yes.
this DM is perusing his written submission and passing this particular order. So thus written submission is not part of this, my lord, writ petition, neither the memo of appeal.
It's 210, madam.
210. Very good. Lordship kindly sees, my lord, 210. What does it say, my lord, in his in his written notes of submission?
Yes.
Thank you for giving us an opportunity for so and so. Main issue in our case is unlawful suspension of unlawful suspension mining so and so. Unlawful suspension resulting in denial of a lawful rights of mining period for excavation. Suspension resulted in what? Delay in providing position. Unexpected suspension of operation was done without giving opportunity of hearing. Delay of 22 months. Reasons iterated in suspension order as obtained from RTI based on the anticipated royalty for 5 years. Suspension order dated so and so are disposed after 3.5 months after expiry of justice delayed, justice denied. Our submission of the fact of issue iterated above are specified for your consideration. Delay in providing position. This is one part of his argument. Abrupt suspension of operation without providing opportunity as another part. Reason of suspension neither specified nor remedial measures or penalty compensation imposed. Delay in conducting of hearing. Reason of suspension obtained from RTI, vague, ambiguous, based on anticipated royalty, along with lease rent collected by department, so and so.
Yes.
So suspension order 7 March disposed and closed. That is what he says. 7th March at page 213. Ultimately, our suspension order dated 7th March was finally disposed and final order dated 23rd December 2023 was issued by the district authority after 3.5 years of prolonged persuasion, resulting in our LTML deed being given a silent burial and no remedies provided during the period beside the order was issued and based on suspicion of illegal mining and apprehensions that our operations would create law and order as per LTML deed part so and so. 5. Any of the terms, conditions, so and so. In the backdrop, with a humble submission to consider, we would request you kindly advise the district to authenticate the facts of review and consider their order so that restoration of LTM is provided to enable fair opportunity to exploit dispose. So his, my lord, fiscal loss which you have suffered. So his focus of his notes of argument is that we want extension. That is his foundation. Naturally, my lord, he lost his years. So, my lord, upon perusal of this, my lord, this DM, what does he say, my lord? It is very, by this time, lordship has already gone through. So, he is focusing on the extension part. Extension for delay in position, he has given, my lord, kindly sees. On the issue of position story, what does he say, my lord? In this, at page, my lord, 224. In this connection from perusal of record, office file, it appears that immediate after registration of lease deed on...
Sir, Gali, please show me with regard to the decision on the show cause first. Show cause.
Decision on show cause so far as 7th
Suspension.
March 2020 is concerned, my lord. My lord, only, my lord, at page 228.
228, yes.
Thereafter, on 7th March, the second paragraph.
Yes.
Based on report of SDPO that your lordship was referring to, was going through 166, my lord. The sand mining operation of the petitioner was again ordered to be suspended due to report on illegal activity done as a leasehold area of the petitioner. There were specific charges in the said report regarding use of heavy machineries using damages to the water supply of PHE in the riverbed and others. Thus, the discontinuance was due to illegal mining on the part of petitioner. However, in compliance of the order dated 9th June 2025 of the learned divisional commissioner, a joint team for verification of mining activity was formed and the received report has been scrutinized wherein the team has mentioned all these. So, my lord, so this report has been quoted. Based on this report, it is not possible to figure out claim of compensation to the state government for loss due to the illegal mining activity done by Lazy and the provision of clause 29 of part 7 of the lease deed. So again, Milord, he is coming back to extension part. So, Milord, with regard to
part, there are two parts.
Milord, so with regard to the suspension part dated 7 March 2020, this is the light he's throwing, because he says that I have conducted the joint inquiry team. I formed a team. I conducted a report, and report was placed before me. I scrutinized the report. Now, this report
does not show anything.
This is the report he has quoted.
Does not show anything against him, because
It is not against him. So, Milord, prejudice for non-supply.
Now, Mr. Gali,
Lordship,
please turn over to the order of remand. Please turn back to the order of remand.
Milord, page 208.
Page 208. So
Very much against.
Page 209.
That you did not conduct any previous inquiry. You slapped simply a report. All these things were
the
said.
absence of any field inquiry, if you say it cannot be done,
But
so
Milord,
how can you?
so far as the suspension, Milord, so far as suspension part is concerned, 7 March 2020, as on date, Milord, as it will not fell from your lordship also, that it is academic as on date, because legality of the suspension, that is 7 March 2020, because joint commissioner is also telling that you did not hold inquiry in the year 2020 before slapping this particular show cause notice. Thereafter, he says you hold a joint inquiry. Joint inquiry when? In the year 2025. Now, on the day I am going to the...
not challenge the order of the appellate authority. That's binding.
No, we have complied with the appellate authority order.
So,
joint inquiry held.
The appellate authority's view was that without field inquiry, you cannot do anything. At that point of time, there was no field inquiry, and the appellate authority directed field inquiry. Thereafter, field inquiry was undertaken, but nothing against him.
Because the 2020 incident will not reflect in 2025 in the field.
That is so. Allegations remains unproved.
Milord, Lord, I should be very candid. Milord, I represent Article 12 authority. Milord, I can't, Milord.
There is no basis of suspicion. Milord, if it goes,
even if it goes, Milord, as on date, Milord, assuming but not admitting, even if it goes, Milord. But Milord, conclusion is inevitable.
What conclusion is inevitable?
The
extension will not be granted.
Because contract, it is a contract. It was a concluded contract.
Please show me the clause of the contract with regard to force majeure clause.
Force majeure clause, Milord. It is there, but force majeure clause, act of God, and this and that, Lordship.
Please kindly come to one.
Lordship. Milord, may I take your Lordship, Milord? Respectfully invite your Lordship.
I think part 9.
Part 9 plus 5.
Page 98. 98 is the relevant, clause 5.
Plus 5.
Milord, 98, clause 5 at the bottom.
Yes, please place that.
Failure on the part of the lazy to fulfill any of the terms and conditions of the lease shall not give the state government any claim against the lazies, or be deemed to be a breach of his lease insofar as such failure is concerned by the state government to arise from force majeure. And if through force majeure, the fulfillment by the lessee of any of the terms and conditions of this lease be delayed, the period of such delay shall be added to the period fixed by this lease. In this clause, the expression force majeure means act of God, war, insurrection, riot, civil commotion, strike, tide, storm, tidal, fire, and other happenings which the lease could not reasonably which the lazy or lazies could not reasonably prevent or control. So force
meant by other happenings qualified by the expression which the lessee or lessees could not reasonably prevent or control.
Milord, this is, Milord, it is, Milord, governing the earlier part. Beyond the control, it is relating to, Milord, something.
Mr. Gali, why then there are two things. Act of God, force majeure, we all know that force majeure, act of God is one thing. It's beyond nobody's control. That's exactly what is force majeure clause, act of God, and other thing. It's beyond anybody's control, either the lesser or the lessee. Then why other happenings is qualified by the expression which the lessees could not reasonably prevent or control? Why only lessees? It should have stopped at that, because if according to you these other happenings is to be read ejusdem generis with the earlier part, then there was no necessity to qualify the other happenings with the following expression.
My lord, if my learned friend,
The
lordship,
other parts,
lordship,
before other happenings, all is beyond control of either lesser or lessee. Either lesser or lessee.
so my lord,
Then why this is qualified by
my lord,
saying it's beyond the
in
control of the
respectful
lessees?
reply to your lordship, in respectful reply to the query of the honorable court, my lord, other happenings which the lessees could not reasonably prevent and control. This part of this clause, my lord, is related to certain actions, incidents, and omissions which are beyond the control of the lessee or lessees. So here,
Give me one or
statutory
two
authority,
examples.
my lord,
Can you give one or two
here, my
examples
lord,
for that?
statutory authority. Here, statutory authority has taken an action against him. Certainly, the statutory authority.
No, can you, not on this matter, can you give me some examples of other happenings, one or two examples, which is beyond only the control of the lessee, for which this other happenings extension can be granted? Please give one or two examples.
My lord, there might be administrative reasons and also non-administrative reasons also.
Non-administrative. Administrative is for the default of the administration. Let us not take anything which is for the administration. Non-administrative reasons, give me one or two examples for that.
My lord, lazy, my lord,
Which is beyond the control of the lessees, and it's a force majeure clause. Please, act of God, and can you give one or two examples of that?
my lord, these
Cannot be related to this matter. Examples.
examples, my lord.
It's only beyond the control of the lessees. And it has to be according to act of God. Explosions.
Well,
other
act
things.
of God is also beyond the control of the authority also.
Yes.
Authority also cannot
Yes,
control.
thank you for that. Then
It cannot
should not have
control.
been qualified, the last part.
No, but here, my lord, kindly
That is why
appreciate.
I'm asking you.
No, because
Other happenings,
no,
can it be read ejusdem generis with the earlier part, or it is disjunctive, qualified by the subsequent expression?
since it is, my lord, force majeure clause, it is giving a benefit to the lessee. This part is a beneficial clause for the lessee.
Mr.
So it is because
And other happenings which the lessees of, why this expression?
as because my lord, kindly sees, my lord, the sentence starts with failure on the part of the lessee only. The sentence in clause 5, my lord, starts with the word failure on the part of the lessee.
Appreciate that. But all these expressions are beyond control of both lessors and lessees. Then why this qualification? What's the necessity of
My lord, as because here this part,
incorporating this expression?
my lord, this part is dealing with general provisions. It is general provisions.
One or two examples of only which the lessee is only beyond the control of the lessee.
My lord, here this lordship, as of now, my lord, I can't recollect the examples or illustrations. But here, my lord,
I can give you another day for that also.
but here,
5 minutes for giving the example.
lordship,
Think about that if you say that.
My lord, even if my learned friend, he has referred to Rule 21, Sub-Rule 4, Clause D.
Mr. Galib, 21 he cannot succeed. 21 he referred to, but my query to you is twofold. One is, if that suspension, no decision, effective decision, then it goes that it's not for him. It's for the authorities, not for his failure. Then question of extension can be only under clause 5. No other clause says that extension will be granted, subject to correction by you. It's only clause 5 which provides for extension in the lease.
Lordship.
So no other clause. So it's only under clause 5 extension can be granted. So unless he comes into 5, under 5, he cannot get extension.
Milord, extension, Milord, the prayer which is making, it is, Milord, a substantive right which is not at all granted even with the statute rules governing the field.
If it is an agreement, you are bound by that.
Milord, this agreement is circumscribed by 2016 rules and the present rules which govern the field. It is very much clear from the other part of the agreement also.
According to you, clause 5 is ultra vires the statute.
No, not ultra vires. It is governing. It is governing the other provisions of the contract. Other provisions, it is very much, I can show you, Lordship, from the other clauses that first it is governed by 2016 concession rules, and other clause is there that the parties are governed by the existing rules governing the field. So both are, Milord, being a concluded contract, both are, Milord, bound by this contract. So whatever, even if the rule 5 or clause 5 at page 90 is to be read, to that extent, but it has to be, Milord, circumscribed, Milord, within the periphery of the entire contract. The sum and substance. Milord, Milord,
there are several
the
decisions wherein extensions has been granted.
But, Milord, I can show, Milord, authority of division bench where it has been deprecated since after coming into force of 2016.
Justice Banerjee's decision.
No, Milord, Justice Bosch's decision. Milord, after coming into force of 2016, 2021,
so please give me the division
sand policy. After that, Milord, no renewal, no extension, nothing of those. On the date of expiry, on the date of expiry, it will vest.
No. That's well settled. That's
Settled proposition.
But the only thing is that some decisions of the coordinate bench allows extension on some grounds, taking aid of clause 5 of part 9.
Force majeure.
The learned is aware of that.
No. In that is not. IIAM and Shopon Kumar, not at all. No, Shopon Kumar went for MAT, and Shopon Kumar was a different aspect.
What Shopon Kumar?
Shopon Sarkar judgment.
No, not Shopon Sarkar. There are other.
Radharamon construction lawsuit, in that particular case, there was an admission on the part of the authority that because of the restriction imposed by the district magistrate, this mining activities of the lessee affected for a certain period. Considering that admission, the extension was granted.
Not sure.
So it was recognized that there is a provision for extension. This was applied.
No, Lordship, the thing is other happenings, as your Lordship pointed out, the other happenings, the coordinate bench considered these as other happenings, that since there was a restriction imposed by the authority, it was beyond the control of the lessee. So that's why this Honorable Court, considering that aspect, granted extension of 11 months.
So that is what I am saying. So other happenings.
In one matter,
extensions have been granted taking aid of clause 5. If it falls within clause 5 extension, it does not fall within.
But in that particular case, there was the authority admitted that this is the.
That is a different, Milord.
Those are factually different things.
Yes.
But my question to you is that extensions under clause 5, if it falls within clause 5, extension is permissible, even if after expiry.
Milord,
point out only that they are the coordinate.
Following that, in Radharamon construction, extension was granted, and so far as the other judgment that my learned friend has handed over to your Lordship, in that case, only after a certain days of enjoying the lease deed was suspended.
Minus 10 days.
On the
10 days.
On the ground of there was serious.
No,
the Honorable Court came to the conclusion that there are provision in the lease deed as well as the statute. You ought to have invoked those provisions. Instead of invoking those, you merely suspended it and allowed the lease to expire. So on that course, the extension was granted because the statute provides for taking up penal action against the lessee for violation of the terms and conditions of the lease. Instead of adopting those recourse, they only allowed the lease to expire upon only suspending. For that reason,
All
it
right.
was extended.
Mr. Galib, anything more? I can hear you. Anything more?
So, my lord, this is, my lord, what kindly sees, my lord, the other clauses, my lord, if I may refer to,
Of
the lease deed,
yes.
lordship.
No other clauses for what?
With control over and, my lord, and regarding one clause, I want to show your lordship. So his second show cause was causing danger to the
Riverbed.
riverbed. The second show cause, my lord. So that is permissible.
Of March.
Lordship, 7 March 2020. That is very much permissible. It is one of the clauses also that causing danger, they can do it.
But that is there. But if it is proved.
As on date 7 March 2020, whether it is legal, to be very candid,
It's academic.
not only academic, if your lordship places a query to me that whether you have given any conclusion or considered opinion with regard to 7 March 2020, that is not there. He has dealt upon only extension story, but skipped impliedly thinking that it is academic now, therefore why should I focus or deal with all those? So as on day 7 March 2020 remains, observation or consideration of the authority remains inconstitutional. Lordship.
Its natural
There is no this determination of the issue.
natural death because the lease.
Lordship.
If the person or employee is suspended, with his date of retirement, that order of suspension will automatically
go.
Your Lordship, have considered this as an example. If an employee is suspended by his employer during the course of his employment, and with his date of attaining superannuation, the order of suspension will automatically.
And if the order of suspension is set aside, what happens?
We will get consequential benefit.
What consequential benefits?
Salary for the suspended period.
Here, consequential benefits. So, consequential benefits you will get upon holding that the suspension is bad. Now, here, if it is held, suspension is bad, what will be the consequence? For your fault, he is not so. Whether it will come with, whether it will come within other happenings.
Damages.
Whether it will then come under other happenings or not. The example you have given can be applied here also.
So, my lord, this
friend has given that example. So, thank him. I'm thanking him for giving that example.
Lordship. My lord, so, my lord, my respectful submission would be, my lord, page 69, kindly sees.
Yes.
So, this particular, my lord, contract is circumscribed, my lord, by, my lord, 2016 rules. Kindly sees the last 4 lines from the bottom.
69.
Page 69.
Yes.
Last 5 lines from bottom.
Yes, 2016 rules. No dispute with
now, my lord. Now, my lord, next clause, my lord, kindly says, my lord.
So for what point, Mr. Gali?
As because we are, both of us, are ad idem on the terms and conditions.
Yes, nobody can depart on the terms and conditions.
So, my lord, no, I am
accepting clause 5. There is no provision for extension.
No, my lord, just my lord.
Relief is he wants extension. One part, second part is suspension is challenging. These are the 2 parts only.
And my lord, page 95, clause 29.
95, clause 29, what is that?
Both of us, it's a lazy shall abide by all existing laws and rules and regulations enforced by the government of India.
No difficulty.
Not. Now, my lord, modification, when can it be done and how can it be done and who can do it?
So, modification of what?
Kindly see, my lord, page 100, one clause is there, clause 12.
Modification of what?
Of these conditions of lease.
No. Nobody is
Not
wanting
lordship.
modification.
Lordship.
Let us not go into that. One is extension, another is suspension.
So, my lord, my meaning, my lord, of reading these various clauses is because of the reason that clause 5 interpretation, my lord, in my respectful submission, subject to your lordship's correction, is to be done within the periphery or purview of the contract that has taken place
And the
between
rules.
them.
And the rules.
So, Miller, since the contract says that entire activities, actions, and omissions will be governed by 2016 rules and the existing rules and policies, whatever are there. So, Miller, interpretation of clause 5, other happenings is cannot go that extent which will make the rules odious or futile. So, Miller, this is my respectful submission, Miller.
Anything more?
And Miller, with regard to extension,
Yes.
Miller, may I respectfully, Miller, cite this judgment
Yes.
2025, Miller, SEC Online Cal 5320.
Yes.
Here, Milord, the issue, Milord, may I respectfully invite your Lordship, Milord, the first paragraph. The appeal is directed against the judgment and order dated 19th May 2020, passed in WPA number so and so. But the impugned judgment order, the learned single judge dismissed the writ petition seeking extension of time period of the existing lease for sand mining. So, Milord, kindly sees what does the observation is at paragraph, Milord, 14, Milord, if I may respectfully invite your Lordship, Milord. Page 3 of the report, page 14. The relevant paragraph 14, Milord. The relevant rules guiding the grant of lease for excavation of sand mining, that is Rule 2016 as well as Rule 2020. That is Rule 2020 that is auction, transportation storage rules, specifically prohibits grant of extension of time for lease without going through the process of tender. Learned Singhal also noted this fact in the impugned judgment and order and came to the conclusion that extension of time without undergoing process auction would be violative of Article 14 of the Constitution. And therefore, my lord, the single bench judgment was upheld in this particular judgment. And secondly, my lord, Lordship, after this, Lordship, my lord, must have by this time gone through this judgment also that with regard to vested right of mining lease, it is not a vested right after judgment of
Yes.
my lord, this Supreme Court judgment, may I respectfully cite, my lord?
Yes.
With regard to, my lord, right over mining lease. Honorable Supreme Court says, my lord, in one of the paragraphs that it is not a vested or fundamental right. So, as of right, it cannot be. My lord, paragraph, my lord, if I may respectfully invite your lordship to paragraph, my lord, 24, my lord, placitum G.
24.
Placitum G. Para 24, placitum G. Quoting a judgment that is of hind stone. In para 24, it is quoting a judgment that is hindstone judgment. So, Honorable Supreme Court says, my lord, quoting 133 of hindstone, no person has any fundamental right to claim that he should be granted mining lease or prospecting so and so. So, this is with regard to right. My lord, may I fully cite one coordinate-based judgment of your lord, of this honorable court, my lord, that after expiry, you cannot come for, my lord, preferring, my lord, this. My lord, this is
For extension.
lordship. This is 2025 SEC Online Cal 5320, Ashok Kumar Shah.
Ashok Kumar Shah. This is Ashok Kumar Shah division main.
Oh, sorry, lordship.
Division main.
मेरा हेमंत कुमार घोष 25493 of 2022. Yeah, Miller, kindly sees, Miller, the third paragraph from top. Lease agreement 18 November 2016. 10-year expired 17 November 2021. And renewal application 27 November 2022. If I may read out, my lord, the third paragraph, second paragraph at page 2.
Yes. Starts with after considering the rival.
After considering so and so.
Last line of that paragraph.
Yes, yes. So since it is beyond the expiry, after the expiry of the contract, so discretion, such an obligation, once a lease stands expired, the lessee cannot claim any right under such lease. To renew or to execute a fresh lease is a total discretion of the lessor after the lease stands expired. Such an obligation or discretion cannot be enforced through a writ court, inasmuch as for specific performance of contract, writ court is not the forum to issue mandamus. Hence, no memory. My lord, this is the last judgment. I would like to rely upon a division bench judgment of this honorable court. There's MAT Miller, Dilip Mondol. My learned friend is very familiar with all these judgment. Lordship also, I believe.
No, I'm not familiar.
So at least 2 matters I have handed over this judgment to your lordship.
Yes. So, my lord, the very first paragraph speaks of the issue, my lord.
Yes.
Extra copy No, the present challenge has been preferred against an order passed in the petition, whereby the petitioner's challenge to the refusal for extension of a mining lease was turned down by the respondent authorities. Now, my lord, there was stop challan issue was there. Kindly see para 5, my lord.
Yes.
Para 6, it says it is contended by the appellant that due to such stop order for the period between so and so, when the amount was so and so, the appellant was prevented from conducting mining operations on the leasehold land. Accordingly, the appellant contends the appellant is entitled to extension of the period which was lost between so and so due to no fault of the appellant. This was no fault of the appellant. Now, he read clause 5. That clause 5 was relied upon, which we are not. The discourse is on as of now in this matter. Clause 8. That is force majeure was under discourse. Now, what does the Honorable Division Bench say, my lord? Kindly seize, my lord. If I may respectfully invite your lordship. First paragraph 19. So, clause 5 fell into, my lord, consideration. Learned counsel appearing for respondent to designated nodal agency points out that under sand mining policy, as it noted, present lease pertains to sand mining, which culminated in 2020, the mining lease existing at that juncture would automatically not be extended further. This argument part. Now, paragraph
23.
Para 22 and 23. 22 it starts on careful consideration. On a careful.
It starts the finding on force majeure is 23.
Yes, lordship. I'm on lordship.
Derive the middle.
Lordship. So, clause 5 is read out. Thereafter, pertains to a natural calamity, strike, and other happenings over which the lessee could not reasonably have any control. We derive the said meaning from clause 5.
Yes, but
itself. In the present case,
Galib, here it has not been considered the effect of the subsequent expression. Not considered. It has been read, ejus dem generis. With
no, Miller, kindly say, may I read out, Miller? May I read out, lordship?
Please read.
We derive the.
Place this judgment on the earlier occasion.
Miller, we derive the said meaning.
Yes.
From clause 5, that is the force majeure clause in the lease deed itself. In the present case, at best, it could be argued by the appellant that the stoppage of the mining operation was due to unlawful action on the part of the respondent authorities in violation of notification dated May 22, 2027, which, though beyond the control of the lessee, does not come within any of the supervening impossibilities or force majeure as contemplated under force majeure clause. So here is stoppage.
Then the last expression becomes.
Does it really?
Last qualification becomes ocious, Mr. Galib.
Last, my lord.
After other happenings beyond the control, it becomes ocious.
But, my lord, here, my lord, it deals with at base, it could at base it could be argued.
That is why I asked you, Mr. Galib. I'm aware of this judgment. That is
no, after this, so, my lord, Honorable Division Bench was pleased to relegate the petitioner that your remedies before the damage court, civil court for damage, if otherwise permitted. So, my lordship, paragraph 26, we cannot give benefit of doubt, could not be given. Lordship is well, because they entered into this contract with eyes wide open.
Yes.
Para 28, 29, 30. And from 30 onward,
Section 21D.
21D, that is statutory
That's,
authority.
it's a different thing.
So, my lord, clause 5, lordship, as a whole, at best can be, that is the argument, at best he can be said that it was something which was beyond his control. So here, my lord, if the authority has taken an action, certainly it was beyond his control. So beyond his control, other happenings, but my lord, cannot, my lord, other happenings, it cannot, my lord, travel beyond the, my lord, the existing regime.
Anything more?
Lord, these are the, my lord, reciprocal
Yes,
submissions.
what you said.
One thing what my friend
And with prejudice theory, natural justice. So, prejudice is not caused to him for non-supply, as my learned friend is telling. My lord, prejudice or conclusion is inevitable, even if it was.
A prejudice, he has to show how he was prejudiced by that.
Lordship.
Mere non-supply. unless
Lordship,
he was
lordship. So,
some-
prejudice theory, he is not, because it is conclusion will inevitable.
raised a relevant issue that since I didn't pray for extension before the expiry, and that was first time raised before the honorable single bench of this
After
honorable
the
court.
expiry.
My lord, your lordship kindly come to page 143.
That is not a receipt copy.
143.
That is not a receipt copy.
143.
Lordship kindly, we understand.
Yes.
That was given, my lord, in response to the notice of my lord hearing. Lordship kindly take 142A, my lord, before that. The hearing was scheduled on 29/10/2022. The typed copy, my lord, date has been wrongly typed, the typographical error. The the hearing was scheduled on 29th of October 2022 at 4 p.m. In the typed copy, your lordship, it is hereby informed that in accordance with the order passed by the Honorable High Court, Calcutta on 27/4/2021, WPA number 10036 of 2021, in the matter of HON'BLE Niwas Private Limited and another versus the state of West Bengal and others, the hearing will be held on 29/10/2022 at 4 p.m. in the office of District Magistrate Bankura. So he is requested to attend the said hearing before the District Magistrate Bankura at her office chamber by scheduled date and time at administrative building, first floor, along with the original photo, identity proof, and all supporting documents. Lordship, I attended the hearing, and Lordship, this is the respected madam, your Lordship will come to page 143.
Milord, I have this written instruction, almost the same I have submitted before Lordship. Lordship may take a record, you may take a copy also.
Yes, yes.
They have
yes.
repeated the same thing, first, second, third, fourth.
143, yes.
Firstly, firstly, secondly, thirdly, bole.
Yes.
Now, page 143, my lord, in the hearing I attended, my lord, I gave my written version. Your Lordship, I'm not this has reference to your memo number such and such toward the hearing to be held on 29/10/2021 at 12.
So last but one paragraph.
Last but one paragraph.
But then why did you, before the coordinate bench did not point out this? Why you sought for liberty to pay for extension?
Because my brother no order was passed. Again, three
Why you
notes.
sought for liberty to apply for extension then? You have also suppressed this.
But the thing is this, my lord, this here never.
All right, that's one part. What do you say to this division being judgment? It says other happenings and your remedy lies in damages.
It is 2025 SCC only.
The other division bench also says even if during COVID, that's gone.
But COVID does not fall in the force majeure. There are other judgments also, my lord.
Even for COVID,
the COVID,
also,
but always Lordship has pointed out, COVID comes in the first phase. It is beyond the control of both the lesser and the lessee.
Even
so,
then also the division bench said no extension.
This has, what has your Lordship has pointed out, my lord, that's why, my lord, what the first part, the COVID is not government, the first part of that force majeure clause is not applicable in my case. So, my lord, COVID has no bearing in this case. This is only, my lord, whether the second part
may not be bearing in your case, but also here it has been the division bench has said Even no extension for COVID-19.
And COVID falls in the first part, which is beyond the lesser and beyond the control lesser and lessee. God, that is act of God word in, and what your lordship pointed out, my lord, that other happenings which are less, which the lessee and
The division bench has said no, it cannot
COVID
be
is
also that.
yeah, my lord,
Paragraph 23.
the COVID cannot be the
No. This judgment is not COVID-19. The Dilip Mondol. This kindly come to paragraph 23. Clause 5 interpreted by saying, even if it is on the act of
Force
the
majeure-
administrative
force majeure
was-
pertains to a natural
was due to
calamity such
unlawful
as
action,
or other happening.
your remedy lies elsewhere.
But this is
There was also an illegal stoppage. A stoppage transit or stop order something. Stop challan.
Challan stopped.
So challan stop. So in a way, suspension. In a way, suspension of the
Of the
activities.
activity, mining activity.
Suspension of activities.
Mining
A
activity.
different name. Suspension of mining activities. So remedy lies in damages.
but in that event also, my lord, the extension part, my lord, the thing has
Cannot
to
be. It has been
Well,
held 23.
the show cause has to be, your lordship kindly come, how the show
Sir,
cause has
that
been
is why-
decided. How the show cause has been decided, lordship kindly come to the order.
Sir, that's become academic now.
Kind-
Even if I hold in your favor, you are not entitled to extension. That's the ultimate thing which you want. And your entire argument was for extension. Because unless you are entitled to extension, you have
But
nothing.
they have made my argument, they have dealt with my argument in the part of the extension, because this honorable court said that in terms of my
Even if accepted, unless you get extension, you get nothing.
But let it be decided, my lord. 7th March 2022, whether legal or
Anything more you want to
and one
submit?
thing, my lord, that's lordship kindly come to page 231, the operative
Yes.
part of the order.
Yes, 231, yes.
Hence, the prayer of the petitioner
Yes.
regarding resumption of mining lease is considered and disallowed with strict adherence to the field enquiry report as conducted on 9/10/2025 and written submission of the petitioner. 9/10/2025 field enquiry report never suggested that.
9/10/2025.
That is the field
that?
enquiry report.
Enquiry
Field enquiry report.
The quoted part, this inquiry report is dated.
This is joint, but
This is the inquiry report.
It is not absolutely not, my lord. The field enquiry report never
allowed
suggested that.
strict adherence to the inquiry report as conducted.
Into 2020, this inquiry report, which is being
How have you, he has adhered to? It says it cannot be done and it has been adhered to.
If it is adhered to, the order will be contrary.
no adhered to in the sense he says
Considered.
no, he's a divisional commissioner has directed him. He's in compliance thereof. He's telling, I have complied in place of
No, my
in place of compliance. He's using adhered
Can you
to.
kindly see the next paragraph? That has been recorded separately in the next paragraph.
All right.
The commission.
Anything more?
And my lord, the AGN construction judgment has been, my lord, distinguished, what I have handed over to your lordship.
Which
by my-
judgment?
AGN construction, which I handed over to your lordship. That in that case, my lord, they continued the mining activity only for 10 days. That's why this order was passed. But they distinguished the fact that in this case,
Actually, this.
my lord,
I thought that in any decision.
no, AGN, no, what I cited.
JHN.
JHN.
Yes.
Yes. That has been distinguished. Sorry.
Yes.
That has been distinguished by saying that in that case, my lord, the mining activity continued only for 10 days. In this case, lordship, even if I accept that the mining activity continued for after the possession and before imposing the second notice of suspension, that is only, my lord, January 16, 2020, the possession certificate was given on page 132. Your lordship kindly come.
Yes.
And my lord, when the second notice of show cause was given, the 7th March, how many days, my lord?
All right. Anything more? Heard the landed advocates for the parties.
Application, you have freedom.
6.7 একসঙ্গে করে দিন। Yes,
আমাকে ওই-
call the next matter.
এটা নাও।
Whose book is this? নয়, কোর্টের বোধহয় এইটা। দেখে হলো বাইরে। দেখে নিন। Yes, call the next matter.
Item number 8.
তোর বাইরে আছে।
My lord, 8, my lord, I appear for the petitioner, my lord. Ready.
Yes,
My apologies, me, my lord.
Yes, what do you want?
My appearing, my lord, virtually, my lord. My lord,
Yes.
this is a very innocuous prayer, my lord. That, my lord, petitioners is the owner of the property. That the names are not recorded. I applied before the BLRO for correction. My lord, that was not considered. I prayed before the learned land tribunal, my lord, to consider the representation. My lord, that was directed by the learned tribunal to consider my representation by the BLRO. But since it was not done, we prepared another application, original application before the land tribunal, and further prayer was granted and directed the BLRO to, my lord, hear the representation within 3 months. My lord, during the hearing, my lord, I found that the lands are vested under the West Bengal Estate Acquisition Act. So, my lord, thereafter, my lord, I preferred an appeal before the DLRO. But my only prayer here is, my lord, to supply the vesting documents or the vesting order, my lord, by the state respondent. But my DLRO, the proceeding, the appeal proceeding before the DLRO is still pending. My lord, supply the copy, my lord, then, my lord, we will challenge before the appropriate forum. My lord. Prayer A, my lord, I have stated it. Only this portion, because, my lord, this is scheduled act, my lord.
If your lordship, my lord, kindly, this is the case, my lord. First of all, my lord, this is, my lord, 5A7. Kindly see the, my lord, paragraph 2 of the petition.
Yes.
So paragraph 3.
Yes.
Thus early during his lifetime on 26 December 1955, he has transferred his land to his son. The misty period of transfer is 5/5/1953 to the date of vesting. And he has purchased in 22, and order has been rejected. And my lord, if your lordship kindly come, now what is
Mr. De, the appeal is pending before the appellate authority.
appellate authority, and then he has to approach before the
So,
tribunal.
Appellate authority, my lord. Appellate authority.
You liberty to apply for the copy before the appellate authority.
Yes.
Please apply for that copy before the appellate.
My lord, so that, my lord, they can supply.
Yes.
Oblige. Oblige.
Without section 5, appeal has been prepared. Appeal, my lord, thereafter, another order of
That is the issue, my lord. That is the issue, my lord, dealt with by the
After some
DLRO.
argument, to play,
my lord.
not directed to supply. Yes, if it is service taken on record. Yes, call next.
Item number 9.
আচ্ছা ওটা লিখে দেবেন মিস্টার মাহাতো লার্নেড অ্যাডভোকেট অ্যাপিয়ার।
Briefটা দে।
Yes.
My lord, I am appealing for the,
Yes, what do you want?
my lord, firstly, my lord, there is a, my lord, private respondent.
Not
What?
served.
One of the private respondent has not yet received. My lord, he has refused, as I've been told, but the server copy is not.
Next
My lord,
week.
let it be on Tuesday. My lord, earlier occasion, my lord has fixed that matter on Tuesday.
On the prayer of the learned advocate for the petition.
Item number 10.
10 is also same.
But item number 10, my lord. But I am led by Mr. Partho Pratim Roy, my lord.
Yes, yes.
But the matter relating to my lord, kindly come to page number 28 of the representation, P2. That my lord, around my land, my lord, there is a mining activity. The open OCP, the opening
Yes,
mining
who is the
activity.
respondent?
But-
Have you served the respondent?
My lord,
May I find my
Who is appealing for ECL?
ECL is the without hearing me, my lord, without any compensation, without acquiring my land, my lord, the OCP, my lord, the land mining, the mining is continuing, my lord. The coal mining activity. Only, my lord, to consider my representation P2, page number 28.
The petitioner claims to be the owner of
Item number 11.
The 11, I beg to appear on behalf of the petitioner, Lord.
yes.
My lord, petitioner has been blacklisted, my lord, without giving any opportunity of hearing. It's a sheer violation of natural justice. Lordship may kindly have
Blacklisted by whom?
blacklisted by the authority, my lord.
Which authority?
My lord,
Tender matter.
tender matter.
Yes, Lordship.
My lord, it is coming within the purview of my lord Group 1
Land.
land. Because my lordship may
Where is
kindly,
the impugned order?
yes, lordship kindly sees page 98 for a moment. Order dated 3rd of February 2026. My lord, this order, my lord, debarring me from my lord, participating in any tender for a period of 3 years. Number one. And my lord, my bid security amount has been forfeited. 29,33,000 has been forfeited without any show cause, without granting any opportunity of hearing, nothing. My lord, when my lord, I'll just show it to your lordship, my lord. Initially, I was declared as H1 bidder.
Yes, madam, have you got instructions?
No, Lordship, we have to take the necessary instruction, Lordship. Kindly,
So, day after
no, 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 Lordship, kindly give 7 days time, Lordship.
No, my lord,
Why 7 days time?
7 days time, Lordship, kindly. Yesterday,
my lord, in
yesterday
respect
got
of
this bid,
this,
Lordship.
my lord, they have floated a next tender because, my lord, this tender has been cancelled. Cancelled in
What is the date of
Lord, the last
when it
date,
will be opened, or the bids have to be submitted.
bid,
when?
my lord, already open. Bid
Already
already.
opened.
Yes, I have annexed, my lord.
Mr. Chakraborty, you cannot participate now.
No, my lord, I can participate. It has not been closed. My lord, the last date
That
of
is why I'm asking you. You have said the bids are open.
open.
Submission of bids have opened.
Yes, my lord, 6th of March is the last date.
Which date? It's the last date is till which date?
6th of March is the last. 5th of March.
5th of March. So I'm keeping it on Monday.
Lordship.
Lordship, kindly give it Wednesday so that we can take the necessary instruction, Lordship.
Why? From where?
Yesterday,
My lord, there is another problem, my lord, I tell your lordship. My lord, I have
Yes,
participated in another tender, my lord, where I have been declared as H1 bidder. That also, my lord, I am being debarred.
The learned advocate appearing for
Yes,
the
Lord.
Item number 12.
My lord, the affidavit of service may be kept.
taken on record. Yes.
The next matter, I am appearing on behalf of the petitioner.
Yes.
Here's my affidavit of service, Your Lordship.
Yes. What do you want?
Your Lordship, I am the owner of the land. My mother deed annexed at annexure P1, page 14, and page 22. That's a deed executed by me, Your Lordship. The Haripada Vishwas sold me a land, 30 kata of land, to Mr. Sudeep Chakraborty.
What's the e-auction notice? Why?
That's a HITCO claiming that they are the owner of the land and the e-auctioning of my land. Record of rights, it's entrusted with
Where
me.
is the HITCO? Who is appearing for HITCO?
I have served the HITCO, Your Lordship, the affidavit of service clearly.
Who appears for HITCO? Mr. Obrotos Majumdar, I think, appears for HITCO.
He's not a.
Pass over, ask him to come. Yes, next. Call the next matter.
Item number
matter.
My lord, I am for the state, my lord.
Yes.
But I want to intervene in this matter. The allegations have been made against me.
Must have done something, Mr. Mujumdar.
Nothing, my lord.
Even then you have been implicated.
This is the only difficulty. Completely pure civil dispute in any event, my lord. My lord, let a copy be served upon us. We have got a copy from the Shartok.
Mujumdar has raised this contention before a coordinate bench, and my lord,
So what is this? Disciplinary departmental. What is this? Complete the investigation.
Yes. হ্যাঁ জানি তো আমি তো বলবো ওটা গুড ল নয় এখানে
The earliest to show cause shall not be changed and handed
মানে
over.
material facts have not been disclosed in the writ petition.
My lord,
Who are you, Mr. Mujumdar?
my lord, I am for the state,
I am the accused.
and petitioner has suppressed the fact before your lordship.
All right, please serve a copy.
Identical matter is filed before the Alipur police station.
My lord, will take it up at 2 p.m. my lord, because Mr. Chatterjee is leading me, Mr. Saurabh Chatterjee, your lordship will take it up at 2 p.m.
Then tomorrow, because
My lord, tomorrow.
there is a, I think, original side.
My lord, one matter is there only, my lord. In the original side, there is only one matter. But I've checked up the list.
My lord, please keep it tomorrow.
Underestimating
In
the
second half,
original
there
side
is-
matter. What can be
My
done?
lord, may I come back after 2 p.m.?
My lord, in second half
But
today,
there
I
is
will be
no-
engaged
there
in
is no
5:51,
urgency,
my
I
lord.
tell you,
Please
lord.
keep it
Very
by
much
tomorrow.
urgency, my lord.
Tomorrow, come
Come
tomorrow.
My lord.
tomorrow.
Next. Not today. Yes.
Deeply obliged, my lord.
Yes.
Consider appearing online, Lordship.
My lord, 16 I beg to appear for the petitioner, my lord. Am I, my lord, am I audible?
Yes.
My lord, I'm appearing on behalf of the state led by Mr. Shapon Bandyopadhyay. Led by Mr. Shapon Bandyopadhyay. He is engaged in other court, but he is being
Then tomorrow.
tomorrow, my lord.
Tomorrow. Not
My
today.
lord, tomorrow, my lord, my only difficulty is tomorrow I will be travel from one part to another, my lord. Can it be on fast hub? Cannot be on top, my lord. My earnest request, my lord.
Tomorrow.
Tomorrow top, my lord.
Yes. It's fairly at the top. Yes. Not today. Yes. Next.
service.
That-
That is point number 5.
Tomorrow, if it
Your Lordship, e-auction is going to be held today, Your Lordship, 19th February. E-auction of my plot of land today itself. It's e-auction
when
is
the auction notice was published.
auction notice was published on Your Lordship 13 January 2026. Your Lordship, thereafter the
Remembers this matter, my lord, this appointment of an arbitrator under Section 11 of the Temporary Provisions Act. On the last occasion, it was lordship desire, my lord, to inquire of, my lord, the respondent as to what was their mode of calculation. The amount that they had computed, which we had disputed, what was the mode of computation? You know, they are supposed to show this, but my lord, I was doing some research. So there are basically, my lord, 3 garment orders which are required to be looked into.
What are they?
My lord, I'll indicate, my lord. First is, my lord,
Next to these,
no, because I don't have them. My lord, page 52 refers to the first GO, which is dated, my lord, 5th of April 2015. Kindly see, my lord, page 52, the 3rd paragraph.
yes,
However, it was detected later that the relevant GO being such and such dated 5/4/2015.
yes,
Well, what initially happened was the initial calculation was something to the tune of 3 crores an odd. Then they brought it down to 296. If Muller takes the next page, page 53.
yes,
So Muller, their initial calculation was something to the tune of 367 and odd, which was Muller brought down to 296.
yes.
So Muller, this is on the basis of Muller this GO of 2015. So this is the first one. The next one would be Muller appearing at page 56. Kindly sees Muller page 56.
Yes.
Kindly sees the last line. Just above Muller, this may be kindly treated as urgent.
Yes.
Just the line above Muller, the revised guidelines video memo number such and such dated 16/6/2022 also provide for enhancement of rents. So Muller, these are 2 Muller GOs which I believe Muller probably have to be looked into to determine as to Muller, the nature and the mode in which the calculation has been Muller.
Yes, that's one part. Now the other part is at what stage this arbitration will be. Arbitrator has to be
Well, look,
appointed.
According to what our contention is, Muller, whenever there's a dispute as regards Muller, the rate of compensation. So this could be Muller at the first stage
Or at the subsequent. Or
stage.
at every stages of extension also.
Yes, Muller, yes, because
Or every enhancement.
any enhancement, Muller. I say in our case, Muller, this from 89 onwards, there's no question of enhancement. It's a fresh determination. So at least at this stage, Muller, the arbitrator has to be appointed.
Why fresh determination?
Because Muller, the
initial extension.
No, Muller.
Or enhancement.
No, what I say, Muller, the earlier determination was in terms of an order passed by this court appointing an arbitrator till 89. And that is Muller made explicit in the award passed by the arbitrator. That was till 1989.
Yes.
Muller, thereof what happens, Muller, the Requisition Act comes to an end 92, Muller, and therefore Justice Tandon's order comes in. Now, Muller, for the period subsequent to 89, there has been no determination. I would have understood there had been a determination.
Your Lordship heard this, Lord, on the last occasion, my Lord, what fell from your Lordship also, my Lord, after hearing both of us, just, my Lord, to recapitulate.
Well, something
Yes.
dawned in my mind.
Yes, I just want to, my Lord, recapitulate.
Today or so. I do not know.
We will try to, my Lord.
So I have forgotten everything.
That's what I want to just recapitulate, my Lord, once, my Lord, so that we don't waste your Lordship's time again. My Lord, what fell on that on the last occasion was 89, my Lord, under the Temporary Act, a requisition was made. This is an admitted position. Now, my Lord, if that is the case, what happens is, my Lord, a compensation is to be given. And the requisition, my Lord, maximum period is 25 plus 5. And then after that, you cannot hold, you have to give it back. This is the, my Lord, scheme of the Act. Now, my Lord, they went to court, my Lord, they invoked section 11, subsection 2, my Lord, and asked for an arbitrator. That, my Lord, arbitrator entered reference. Arbitrator has to be, my Lord, district judge. Like, my Lord, under the 1948 Act and various other, it is usually the district judge. And any appeal to the High Court. Now, my Lord, district judge passed, my Lord, an award till 89. What they did is, my lord, several litigation, my lord, was there. Because there were two aspects of this requisition. One was under 1948. That, my lord, happened in three phases, which is 1965, 1979 and 1986. Three phases, my lord, requisition made under the Temporary Act. And parallelly, my lord, under the Land Acquisition Act also, my lord, there was a notice under Section 4, my lord, in 89 and thereafter a declaration. But since the collector, under the Land Acquisition Act, did not pass an award, my lord, within the particular time, my lord, that lapsed. They challenged that part and also this requisition. This is the requisition. This is not an acquisition. And, my lord, they went before, came up in High Court. There, my lord, Justice Tandon, my lord, passes an order. That is, my lord, in 2018, saying two things. One, yes, your land acquisition has lapsed, but that does not mean that the state cannot acquire de novo again. It can. Number two, my lord, is under the relief undertaking. Yes, I am taking note of the fact that there was an arbitrator who has assessed the compensation component and given you an award till 89. Now, thereafter, what my lord Justice Tandon says is that since they have, my lord, ultimately got back the property in 2023. But at 18, my lord, they did not have the property when Justice Tandon, my lord, was looking into the matter. Justice Tandon said that that compensation, what was there till 89 is not sufficient. You will have to now calculate from 92 onwards. No, first it said, my lord, I am giving you 6 months more time. You have a choice to acquire the property. We chose not to acquire the property. And we handed over possession, my lord, subsequently. But the court said that you give a revised compensation, my lord. That is the term. I showed your lordship, my lord. Kindly just once take that the language was that revision, page 23. The order starts at 23 and the relevant portion, my lord, is at
34.
34.
Last paragraph.
Last paragraph. This court therefore directs the state government to take steps relating to the revision of the compensation for the period of midnight of 31st 99. Why midnight? Because 25 plus 5 years, my lord, ends there. That is why. Till the property is under section 10B, that is the, my lord, maximum requisition period. Till the property is acquired under Land Acquisition Act, or in the event no acquisition proceeding is initiated, the same is physically and actually delivered to the petitioners. Now, this happened, my lord, in 2023, subsequently, 13 January 23. Your lordships may, my lord, note that. The entire exercise shall be undertaken by the state within a period of 8 weeks from the date of communication of this order. Now, my lord, kindly appreciates today what my learned friend is saying is completely contrary to what he was taking a stand, my lord, in 2018. May I? My lord, I am the state, my lord. I have to show to your lordships that I have done whatever I have done right.
And that's usually a Herculean task.
Page
Usually.
Page 36, my lord, your lordship will, my lord, kindly take.
Both of you are right in your own ways.
Your lordship will have to now decide that. Yes, we are. It's an option.
So everyone knows.
I'll tell
Both, as the saying goes, both the parties know who is right. The judge is on trial.
It's an uphill task in some matters, my lord. Just to take change the topic. Well, I am an arbitrator in some matters. At long time, my lord, I had, my lord, seen a moot. But as arbitrator, my lord, it's so difficult because one person is saying what he's saying is right. The other person, my lord, is saying he's also saying whatever is right. The task is when you are writing an award, first you record what he said, then you record what the
Here, don't complicate the issue. Please simplify it.
Yes, that's my endeavor. It's an uphill task. And how your lordships do it on a day-to-day basis.
Don't make my task uphill.
Yeah, that's why I'm saying it is very easy. They should be dismissed. Because the prayer, if you see the prayer, my lord, it's
That's the
untenable.
easiest way.
Yes. They are asked.
That's the easiest way. A suggestion is.
Dismiss because that was the easiest way. But the reasoning should be this. This is probably the easiest way to come out of it, so I dismiss it.
No, dismiss because they are asking for everything all over again. Open the Pandora's box again.
So now let us come back to the first.
So, my lord, 2018, my lord, this order is passed saying you revise, asking the state government to take steps. Now, what they say is, my lord, at that point, they could have said you appoint an arbitrator because now you have to adjudicate from 92 onwards, my lord. They don't do that. Kindly see, my lord, page 36. This is their letter, my lord, to the land acquisition collector.
36.
Page 36.
Yes. Yes.
Kindly see, my lord, they say 11th October 2018, they are writing that with a solemn order dated 10th August 28, Lordship has passed this. Then, my lord, last paragraph. His Lordship was further pleased to direct the state government to take steps relating to the revision of compensation payable to the undersigned for the period 31st March 92 till the property would be acquired, or in the event no acquisition is initiated in the manner and time it is indicated, the same is physically and actually delivered to the undersigned. Next page. In terms of the order, your good office was pleased to issue a memo dated 1st October 2018 calling the undersigned to a hearing on October 12, 2018. The undersigned was granted liberty to file copies upon which the undersigned would seek to rely on. Hence, this representation. It would be pertinent to mention that the learned district judge had entered into reference to adjudicate the disputes with regard to the rate of compensation till on April 18, 2007, whereby and whereunder the learned arbitrator was pleased to inter alia hold that your good office would be liable to pay a sum of rupees 15 per square feet in respect of the requisition portions of the said premises for the period prior to 89. Due consideration was given to the citers, etc. The learned arbitrator, however, was pleased not to grant any relief post 1989. A copy of the award is enclosed. Perusal of the award would show rate 15 per month was fixed at between 80 to 89. The rate is thus rupees 15, which is effective from 1980. And therefore, my lord, this is according to my learned friend's calculation.
As to how the amount has to be revised.
From 92. But two things from here, my lord, may I submit humbly, my lord. One is that he enters my jurisdiction. He says that yes, you have given me a hearing, I am coming to you, you decide. He does not ask, my lord, for an arbitrator or a reference to the district judge under, my lord, 11 subsection 2, which he is asking today. I'll show the prayer. He's asking for that reference from 92 onwards. Absolutely impermissible. And further, my lord, kindly see after this letter, what I do, I don't do anything. As usual, my lord, the state does not do anything. He writes to me again.
It's usual.
What, my lord, what my lord?
I'm usually not wrong.
29th March 2019. But people make mistakes and they rectify. I have rectified.
Yes.
29th March 2019, my lord. He says, second paragraph. Pursuant to the solemn order, a hearing
was called on.
Yes. Yes, 12th October.
Then he was heard.
Yes, he was heard. And we did not pass anything. Then he goes before the contempt. Files a contempt, which is CC.
Then you pass the order.
Let me say that, what I did. In contempt, my lord, Justice Tandon passed further orders. I'll show that. So in contempt, my lord, I give an affidavit, which is at page 41. Kindly see, my lord, this affidavit. Page 44, the relevant portion.
Yes.
So what state does is, my lord, first memo issued on 10th August 20, yes, rent compensation was initially, my lord, state calculated till 31st January 2019. This is paragraph 3A. And we gave them a memo, my lord, of 6th February 2019. That was, my lord, a mistake. Then we rectified that in B. We recalculated it, my lord, till 31st March 2019.
Yes.
And ultimately, my lord, this amount was found. 2 crore 96 lakhs, my lord, was found to be due and payable.
Up to 2019.
Yes. Yes.
Because when did you vacate?
So this was 2020. We did it in two phases.
2020.
Yes.
23.
23.
23. Yes.
So 2019 initially was 89, then 2019, then Justice Tandon said, no, I told you till you vacate, you do it. So again, we did it for that period also. So this is what, and in this entire period, my learned friend never said that under 11 of Justice Tandon, you are wrong. You kindly refer it to somebody. He has accepted this process. So now, my lord, he cannot approve it and reprove it. This is what I want to, my lord, impress upon your lordships. Now, kindly see, this is in contempt, my lord. I say 296. And the money is, my lord, KMC's money. I am only the collector adjudicating. My lord kindly takes the supplementary affidavit once. An order of again Justice Tandon.
Supplementary you are filing today?
No.
It's quite long time back. 3rd April 2024.
Yes.
Kindly takes, my lord, page 8. This is referred to, my lord, at page 46 of my affidavit in the contempt. But kindly see this order. 3rd February 23, this order is passed. Kindly takes, my lord, page 9. Third last paragraph. In view of the above, the respondent number 1, this is the LA collector, my lord, respondent number 1 in contempt proceedings, is directed to take further steps for determination of the rent compensation on and from April 2019 to 12 January 23. So I had shown the affidavit, my lord, in contempt which we filed. There, my lord, I calculated only till 31st March 2019. And my lord, the contemptor was called that why didn't you comply with my 2018 order? And then a fresh direction was given, my lord, that you do it from 19 to 23. Now, my lord, kindly takes the next page again. There was some, my lord, discrepancy in the calculation. And my learned friend's name appears in all orders. Yes. Mr. Bordon, he is there.
He cannot fly away.
Kindly takes, my lord, now the page 12.
Any estoppel against him?
There has to be, my lord, because
Lawyers will be bound by res judicata.
this is an issue decided. I'll show, my lord, this petition how, my lord, is possible.
Yes.
Mr. Ghosh appears for the alleged contemptor, submits that disbursement has been made to the collector and therefore it cannot be said that there was no compliance, etc. Then, page 13. The aforesaid contention is refuted by the learned advocate appearing for the collector. According to him, the quantum of rent compensation was communicated after determination and there was no further modification. So these things were going on. Now kindly takes very crucial page 15, 18th April 2023. Indubitably, a sum of rupees 2 crore 96 and odd minus the tax deducted at source have been paid to the petitioners in the month of April 2023. At the very outset, Mr. Ghosh, learned counsel appearing for the alleged contemptor, tenders unconditional apology for the delay occasioned in disbursement of the amount by way of rent compensation determined by the collector. So, collector will determine is an admitted position affirmed by this court in terms of the judgment and order of 10th August 2018. However, it is contended that certain amount which the alleged contemptor claims to have been deposited with the collector, etc., my lord, not relevant. Now, my lord, 296 given. And then, my lord, finally takes page. I have to show this also. Yes. Page 68 of, my lord, the petition, the last order. Two crore 96 was from, my lord, 92 to 2019. And in here, my lord, pursuant to the direction, the collector as well as the alleged contemptor sat across the table and arrived at a consensus that a further sum of rupees 63 lakhs is required to be paid to the petitioners. In fact, the said amount has been disbursed to the first land acquisition collector as reflected in communication dated such and such. Now, this amount, my lord, we have also already paid. Now, here, a liberty has definitely been given to my learned friend. Page 69, whether the quantum of the compensation is fair or justified cannot be gone into exercise of the contempt jurisdiction. It is open to the petitioners to take appropriate steps in permissible under law. Now, my lord, kindly see the prayers, what my learned friend is asking. Prayer A at page 17. Yes. A writ in the nature of mandamus by commanding and directing the respondents and in particular the respondent number 1 to appoint an arbitrator in terms of section 11 to determine the amount of compensation to be awarded to the petitioners for the period commencing from 92 till 2023 to say the date when the requisition property was physical and actually delivered. Milord, I say, Milord, this money by Justice Tandon, several orders, Milord, compensation was already determined. There is no scope for a reference under Section 11 to determine. Determination, Milord, stage is over. 2007, arbitrator passes an award, good, bad, indifferent, Milord, for this period. He should have, Milord, invoked Section 11, asked for a determination. Justice Tandon said state to take steps and decide the compensation. Repeatedly for over a decade. Today we are in, Milord, this petition is filed in when? 2023. Over a day, Milord, he...
So have you digested that amount?
Principally, Milord, yes, he has taken 296 plus 68 also. And now, Milord, if he wants a revision of this, Milord, it provides. The Act provides, of course. We have, Milord, taken his land.
Gordon, on the last occasion, you had given a copy of that Act.
Yes, I had.
You have taken back.
No, no.
Not Ache eta? Oh, yes. I thought
It
you
is-
have taken back.
It's injurious to my benefit. Why should I take it back?
Yes.
Kindly, Milord, sees. First, Milord will take, Milord, the power of requisition is under 3, subsection 4.
We need not travel that far.
Very well,
because,
very well. I'll go straight away.
we
To
are
11.
11.
Yes. Where any premises are requisitioned under this Act, there shall be paid to all persons interested compensation and in accordance with the principles set, namely B. When no agreement can be reached, the state government shall appoint as an arbitrator, which shall be determined. This is the word I missed. Where any premises are requisitioned under this Act, there shall be paid to all persons interested compensation, amount of which shall be determined in the manner as above. So compensation and determination, Milord, as on date is over. Collector has done it. Before that, arbitrator has done it. They all sat across the table and an amount was paid. Today we are on revision. That is, Milord, 14 capital A. And your lordship was satisfied and said, you show me how you have paid the compensation.
I was satisfied.
Yes, and I got that memo.
Must have noted it. Must have noted his satisfaction.
Yes.
Yes.
14 capital A.
Yes.
Yes.
Your lordship,
So is
your lordship was the opinion that this is not applicable.
No.
Kindly sees. Must be some marking here there.
No. The increase. The rent compensation of any premises shall be liable to be increased or decreased where the rent compensation includes the tenant's share, etc. Not relevant. B. Increased when the landlord incurs expenditure or the improvement or structural alteration. Not relevant. Collector shall, on an application made to him by the landlord in the prescribed manner, fix in respect of any premises the increase or decrease referred to above, provided that the collector may by notice in writing to the landlord suo motu decrease the compensation if no application from the landlord. So he is the landlord, he has to come to me asking for a revision. The rent compensation may be revised only if there has been an increase or decrease in the market value of the premises. Milord 3. So revision can only happen if, Milord, subject to fulfillment of 3A. And B, such revision shall be made on an application made to the collector by the landlord in the prescribed manner. What Justice Tandon, Milord, today by 3rd May gave them a liberty is that whatever compensation you have received, if you are not happy with it, you take steps in accordance with law. Did not, Milord, say that you ask for a fresh appointment, provided that no such application shall be entertained until after the expiry of 5 years from the date on which the compensation was last fixed, provided further that in the case of decrease in the market value, the collector may by notice. Now, these are the provisions for revision. Once compensation is determined, in my humble submission, Milord, with your lordship, I have taken your lordship, Milord, through all these documents since 2018, which revealed that compensation, Milord, was given. It was determined pursuant to orders of court. In such a situation, Milord, there cannot be a question of a fresh determination, Milord, for the same period by another authority. He wants an arbitrator now by a district judge. Collector, Milord, And the compensation can also only be revised by a collector. There is no scope for revision, my lord, to an arbitrator. So either way, my lord, it is not possible. My lord, those is my submission. And my lord, that memo, my lord, I have that that my learned friend was showing when I just came in. We are din 15 data. My lord will take my copy. Lord,
Please give a copy to Mr. Board.
দিন আরেকটা আবার সেটকে দিন আমাকে একটা দিন এই so my lord, I have followed this in 2 phases. It was done, my lord. This I have adopted. Finally takes page 59.
59, yes.
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 Yes. So this will be, my lord, 5th April, at the bottom, my lord, enclosure.
Yes.
5th April, my lord, it will be 2005, not 15.
Oh, it should be 2005.
Yes. So I have, my lord, calculated his compensation in 2019 from 92 till 19, and the calculation, my lord, are at pages 60, 61, 62. This is how I have calculated in terms of my memo. Page 60, my lord, your lordship sees. This is, my lord. So arbitrator did till 89, and my lord, I am.
From July 89, you have started.
Yes. Yes. So no period has been missed. 89, page 61 is again.
Why 2 calculations, 2 properties, 2 floors?
Three floors.
3 floors.
No, why 2 calculations then?
There will be 3 calculations probably.
3.
Oh, first floor and another is third floor.
Third floor.
Second floor.
At the ground,
Oh, no, another is there. Third,
3. 60, 61 and 60.
third floor, northern portion. Third floor, northern,
Area is
southern.
different, your lordship will
Third
see.
floor, northern,
2
southern,
portions.
and first floor is northern.
Yes.
So 3 portions of 2
Yes. First floor, my lord, northern portion 1 to
3
5.
portions of 2 floors.
Yes.
Third floor, 2 portions.
No, third floor 2.
Third-
Yes,
third
yes,
floor-
yes.
Portions and first floor 1 portion.
Yes. Area different. Correct. I bow down. Yes. So for that, my lord, this is my calculation, all paid. And for the subsequent period, in which, my lord, I was in contempt, I did not do. I have done that also. That, my lord, is.
Oh, this I admit it's paid. I admit.
Yes. And now calculation is also there. I've done it in terms of the. Yes, page 56. 56.
Yes.
Well,
Yes, about those.
56, well, 56 refers to another memo, another GO, 2022.
And the calculation is at page 57. Kindly notes this, my lord, this is 23. This was all before his lordship, Justice London in contempt. I had, my lord, satisfied. And this was initially 76. We all sat across, an additional amount was to be paid. That also.
We means the corporation and the first land division
Yes.
collector. We means the corporation and the first land division collector. The landowner was not there. Landowner was not there. We means they.
Memo.
22. 16/6/2020. 16/6/2022.
Revised guidelines. This is a smaller amount, lesser amount, my lord. This is 76. After this, we again paid him also.
Yes, Mr. Vardhan. Give a copy to.
Yes, so those are, my lord, my submission.
The facts are like this, my lord. Till 3 portions requisitioned. 65, 79, 86. 89, my lord, the issue of section 4 notification. Follows it by a section 6 declaration. Matter continues. they are unable to publish the award within the specific time frames. So, my lord, I take out an application saying that the arbitration, thing is lapsed. So the acquisition process is lapsed. So kindly give me back my possession along with whatever compensation that you have to give me. In the meantime, what happened, my lord? Till 89, there was an appointment of arbitrator in terms of an order passed by this court, who adjudicated till 89. So, my lord, now I file this writ petition. Kindly takes up Justice Tandon's order, my lord. Two portions I'll be, my lord, placing.
23.
Starts from, my lord, 23, relevant portion 34.
34, yes.
My lord, it is brought to the notice of the court that an arbitrator was appointed by this court for ascertainment of the compensation required to be paid to the petitioners for requisition of such premises, and the said compensation was determined as far as back in 89, and since then no revision has been made as yet. On the last occasion when I placed this, my lord said that this revision is a loosely used term. It might as well mean determination. My attention is drawn to Section 11 of the Temporary Provisions Act, which provides that the mechanism and the mode of determining the compensation by the agreement, and in the event such an agreement is not reached, the state government is empowered to appoint district judge or the additional district judge and arbitrator. This code therefore directs the state government to take steps relating to revision of the compensation for the period from midnight of 31st March 1992 till the property is acquired, or in the even no acquisition proceeding is initiated, the same is physically and actually delivered to the petitioners. The entire exercise shall be undertaken by the state within 8 weeks from the date of communication. Pursuant to this, I write to them at page 36, informing them of the order. They call for a hearing, Admittedly, they call for a hearing, which I attend, and I file my representation dated 11th of October, wherein, I say that this is the rate at which you are supposed to pay me compensation. So they sleep over it. Then I resort to content proceedings now. In the content proceedings, they pay me the amount. But most importantly, kindly first comes to page 18. In fact, page 17 for once of my supplementary affidavit.
Supplementary.
It is not that I have accepted the money and then put up my hand and said, I am not satisfied with your calculation. Kindly see page 17. Is the letter, dated 31st of March 2023, wherein, the Office of the First Land Action Collector issues me a notice saying that the office will pay me compensation charges amounting to 296 for the period 89 to 31/3/19. Got it, So this is the first tranche. On 31st itself, I write to them, kindly see at page 18. I tell them that I am not happy with the mode of computation. Kindly see, please note, the second paragraph, please note that the amount of such and such is an account of compensation till 31/3/19 as determined by the first land collector pursuant to direction passed in solemn order dated such and such. Then I say, however, our claim in such regard is contained in a representation dated 11/10/18 addressed to the first land action collector, and as such we receive this payment without prejudice to rights and contentions as regards such claim referred to above, and our right to take recourse to appropriate remedy for recovery thereof. So, we lodge our protest on 31st. It's thereafter, on 4th of April 2023 at page 20, that they issue me a check of, since there were two people, there were two individuals who were liable to receive the money, two checks. So these checks are dated 4th of April. So the contention that I took the money and then raised my protest is probably not correct. So it is after lodging of my protest, they went to and paid me the money. This is the first tranche. Similar for second tranche, kindly comes to page 24. Again, they write to me on 10th of May 2023, saying that this is the subsequent amount for the subsequent period, 76 lakhs and odd. They write to me on 10th May, page 24. Page 25, I write to them on similar lines, saying that we are not happy with the computation. It's thereafter, that they pay me this amount on 11/5/25. So, on both the occasions, I have lodged my protest as regards to the computation, the mode of computation and the quantum of it. Now, in the contempt, they pay this amount. But I was still not happy with the quantum. So, my contention is under the Act, there has been no agreement between the parties with regard to the quantum of compensation. And
11 applies.
So I say 11 applies. And I also say, this cannot be construed to be a revision, because a revision would mean that there has been a prior adjudication of determination, and for certain change of circumstances, there has been a revision. I say, this determination of from 89 is the determination at the first instance. So if that be so, then it is open for me to contend, and rightly so, that if no agreement is reached between the parties as regards the quantum, the state government might appoint a person as the arbitrator, the district judge. This is what I came to invoke. Now, since my representation was unheeded to from their part, I came up in the court, two issues would emanate. First thing, I say that I was not happy with the determination. So under 11, I have a right that the quantum should be adjudicated by an arbitration. Well, conversely, my second argument would be, the collector computes an amount. It cannot be, that computation will be sacrosanct. I must have, a right to test it somewhere. If the Act is silent, I have a writ court to come to. So I have twofold arguments. The first argument is I am entitled to invoke 11 and seek for the appointment of an arbitrator in terms of this Act. Alternatively, if that is not the case, to test the propriety of the computation, I am entitled to knock the doors of the writ court. And in such a situation, given the circumstances and the presence of the parties, can always mold the relief. Final stage, can mold the relief. So, but my first contention still remains, is that I was not happy with the computation, the determination which I wanted. I was not happy with the determination made by the collector. And I go on to say that when there's no consensus ad idem, what it says is that when no such agreement can be reached, this language of 11B, does not indicate, in my most respectful submission, a written agreement. It's an agreement.
Yes, orally you can
Orally
also.
So, what I am trying to impress upon, my lord, is that since the amount that they paid was after protest, and despite my protest, it is clear, my lord, that there's no agreement which has been reached between the parties with regard, my lord, to the compensation or the determination of compensation. And therefore, I say, my lord, when no agreement can be reached, my lord, the state government shall appoint a district judge as an arbitrator, my lord. This is the sum and substance of my writ application.
Mr. Bordhan, only one thing. Determination under section 11 should be for what period?
The Act is primarily silent on this. So, I would presuppose whatever determination is there, that should be for a particular period.
What period?
That's not there,
So let us take 5 years. Let us take the arbitrator fixes it for 5 years. Let us take a hypothetical case.
That in my most respectful submission, might emanate from these government orders, from these orders I was
Let us
referring
take
to.
a hypothetical case that the arbitrator fixed or determined an amount for a period of 5 years. Now, after 5 years, there may be a question of further determination if there is no agreement.
Yes.
So let us hypothetically take a case that arbitrator fixes a amount of rupees 10,000 for a period of 5 years. Now, after 5 years, they say, yes, I will give you 11,000. Let us say that they propose,
But
you say,
one indulgence, but this would arise only in a situation, Millet, where the requisition is continuing.
yes, yes, requisition is continuing. Requisition is continuing. So now after that, so let us, they say, they offer you 11,000. You say, no, I want 15,000. So then again an arbitrator for a period of 5 years.
No, Millet. Then again, I go back to the collector and say, just look here, I am not happy with 11. I want 15. So if there's no agreement with the parties,
yes, yes.
again,
Let us say none of you will agree because they will not agree 15. You will not come down to 11. So let us take that there is no agreement. So again an arbitrator. So it will be for a period of, let us say, another 5 years. So let us say the arbitrator decides on 14. So then again they say after 5 years 16, you say no 25. There is no agreement. Again a determination under section 11.
I understand
so
what is coming.
This has to continue
I understand what is falling from Miller. But here, Miller is a case where Miller this hypothetical situation doesn't arise. Presumably because Miller, this court had Miller indicated that this determination should be from 89 to 2023, that is to say on the date when possession is being handed over, Miller. And this computation.
No, I am on the, for the purpose of interpretation of a statute, this hypothetical cases are to be taken up.
Yes, Miller. Appreciate
so
that.
Whether in a case, in a given case, let us, so at every stage of expiry of the period fixed, if there is no agreement, if there is agreement, fine, nothing. So that cannot also, for the first stage also there can be agreement. So there is disagreement, if we can say.
My contention is arbitration. My contention arbitration, someone has to decide, Muller.
Yes. So at every stage of disagreement, there has to be an arbitration.
Because
there is no question of revision by the authorities taking the first one as the basis.
Yes.
That's the sum and substance of your argument.
Why, Muller? Because the revision, as Muller, my learned friend pointed out at 14A, does not apply. Because that revision is Muller two different Muller situations. One is Muller tenant share of municipal taxes and
structural addition alteration.
Yes. So this 14 does, in my most assumption, does not arise, Muller. 14A. But and I go on to say, Muller, if a statute can be interpreted in two different manners, Muller, the interpretation
beneficial to you,
yes, should be supported. And Muller, at the cost of repetition, may I say this, Muller, this hypothetical case, Muller, does not arise in the facts and circumstances of present case, Muller.
Just give me 1 minute to say.
So, Mulud, as things stand, Mulud, today I am not satisfied with the quantum. So I must have a remedy somewhere. I say my remedy lies in by way of 11B. In the alternative, as I said, in alternative, if Mulud feels that this provision might not attract, in that event, Mulud can use Mulud's powers of judicial superintendence, and Mulud mold the relief so as to test the propriety.
Their assessment.
Yes.
Their calculation.
I bow down.
And Mr. Bordhon.
Can the writ court do it?
let us take the second case. So on the second case, so how the writ court will test that?
May I suppose this is mine. If the writ court cannot test that, my lord,
No, writ court they
can, my lord,
has-
can.
No, I'm not on the powers. I'm not saying writ court cannot.
How?
While adjudicating, there has
My
to
lord,
be some
it-
reasonable basis
Yes, my lord.
on which how to say this is wrong, that is right.
My lord can.
Show me the basis
My lord,
of
my lord,
the
kind.
writ court.
My
How
lord-
the writ court will assess that?
My lord, for the writ court to assess that, my lord, that's the reason I said, my lord, we need to have a look at these geos, because it is on the basis of these geos that the state claims to have, my lord,
So
fixed the
according
quantum.
to you, whether these government orders have been correctly applied or not,
Yes,
that is only to be considered.
that is to be considered. Number one, and whether these government orders are applicable in the first place, that has also got to be considered, my lord. So whether, my lord, once they say they have taken refuge under this government orders, my lord, so we'll have to test whether these government orders are applicable in the first place, and if they're applicable, my lord, then whether this computation has been done in terms thereof.
Please make your submissions in that regard.
On what,
Geos.
my lord, there's only one geo I've got, my lord. The other geo is with them, my lord. They must produce it.
I've just asked for a printout. That, but they have.
Give your copy.
Yes,
No,
it
this
is
is-
one I've given.
This is one, but this is
The other one, 2022.
22.
22. It's just coming. It's just coming. The geos are not again, my lord, challenged.
Why? How
No,
can I
no.
challenge?
He is not challenging.
Very. He
But
wants
he
to
can very
see
well
that.
argue on those facts that it's not applicable. He's not praying for setting aside of that memo. You have applied that memo. He can very well say, no, this memo relates to this case. My case is a different thing. You cannot apply, or this geo does not apply to my case.
Very well, Edema. If your lordship, only thing, my lord, he has to come up with a proper repetition for me also to respond to that. Because today this case, my lord, with all due respect, my lord, is not made out here. He has to maybe
Mr.
withdraw it and come back.
Not only, yes, that is one thing. Here, your prayer is, what is your prayer here?
Appointment of an arbitrator?
Yes. Now, if that is accepted, it's one thing.
Yes.
If that is not accepted, you can very well challenge that, take those geos and say, no, it's not as per that geo.
But my lord, for that, my lord, one thing is that section 11B is not applicable. It has to be, my lord,
11.
11. My lord, I said that appointment of arbitrator. That's 11B.
That is, if that is, you are true on that, then arbitrator.
So, my lord,
Now, if it's against you on that, then you can be given a
opportunity, my lord. That's there.
So you can
Yes, then lordship will
give
not
you
be
supply
troubled.
the memo. If you do not succeed
That is
here,
that is the first submission I said, that these memos be assume paramount significance. That was my first submission. When my learned friends coming in, that was my first submission. Because I knew where the
You're
roads would
very-
lead to.
You're very fair, we know.
Yeah, man. I'm proud about it. I'm fair. That's why I said, those have to be looked into. Because my first case is 11B. If perchance I am unable to pursue
11?
11B, appointment of arbitrator.
why? Oh, 11.
11,
Arbitrator is.
no agreement. 11.
Oh, 11 is.
Yes, yes.
There is agreement. 11B.
Yes.
Oh, I was only thinking
No,
of
no.
11. Yes. 11B is arbitrator.
If I'm unable to persuade my lord to hold in my favor as regards 11B, then the next limb of my argument comes. But
So for now, this is all. So
11B.
now we have to decide
No, my lord.
whether
My lord,
it's 11B or not.
what I would be suggesting, my lord, if I can make submissions on that score as well, and let the matter end for.
That case has not been made out, Mr. Bordon, because you have to make out that case. They have to be given an opposition. Another thing, and if you succeed here, you succeed here. Then arbitrator. Otherwise,
Otherwise, my liberty, my lord, too. I leave it to love. At the end of the day, my lord, what I want is a computation to assess the veracity of the computation, my lord, the viability of compensation. Whether this way under this act or on the aegis of the court on 226, my lord, I cannot have a choice. I can't have a choice. I can't have a choice of forum. Those are my submissions.
Busun. Yes, give a reply.
If your lordship is only, my lord, then considering this part, my lord, I would.
Yes, because
Yes,
it's the first
yes.
part is.
I'll say this is, my lord, I'll repeat that and say what my
Don't
learned friend.
repeat.
To
Don't
what? Yes,
repeat.
what my learned friend is saying, my lord, 11B all the more cannot be applicable. One, my lord, it will then be a repetitive process, my lord, for every period. Number two, my lord.
If there is no other provision in the statute, what can be done?
Num
If the statute is silent only with regard to that, look, one thing, there is one determination for one period. Let us take it 5 years because it cannot go continue for long. It's for 25 years. You say yes on the first year, I determine an amount, so it will continue for 25 years. Cannot be that. So a person can approach for either revision or enhancement or determination. In either way, it has to be made one way or the other. So one thing is, if there is one determination subject to provision in the statute for enhancement in the lines as in Premises Tenancy Act, also fair rent. There's a dispute.
there, my lord, 14 subsection 3. The rent compensation may be revised only if there has been an increase or decrease in the market value of premises. So what your lordship is thinking that yes, if you say 92, you given that, and later on when the compensation or the during the pendency, this is happening. Yes, if the market value increases, my lord, that will.
Otherwise, no.
Otherwise, no. So then, otherwise, your lordship then will be creating a statute, my lord, which is not there. Interpretation, my lord,
According to you, there is a provision in the statute for revision.
yes.
So it's the initial determination, then the provision of revision.
Revision and revision within the parameters or confines of that.
To be. There are
So,
two
my lord,
things.
the
One
next
is
question I'll pose to myself is, my lord, once it's revised, that revised value also cannot be sacrosanct. There must be a form to test it.
Then the balance, my lord, now then shifts away
That's a
from me.
different thing altogether.
No.
One thing is that you say that there is no provision, so fresh determination.
No, I don't say that. My first argument is this. It is only in reply to what my learned friend is saying is this, my lord, revision, if the revision is made, my lord, that revision also cannot be sacrosanct.
No. That's a different thing. You can very well challenge.
Yes.
If there is no forum in the statute for challenging,
226.
you can very well
Yes.
approach. That's there's no difficulty on that.
But my lord, I'll take it a little further, my lord. Now, if my learned,
you said no.
I still stick to it. Yes. But what my learned friend now says, my lord,
14A3.
Yes, he says is revised if there has been an increase or decrease in the market value of premises. Now, my lord, if my learned friend says that, my lord, the powers under 14A3 have been, my lord, invoked, my lord, there has to be a categoric finding in the order or, my lord, in the report or the mode of computation that this, look here, this was the market value in 89, this is the market value today.
Very well, that is subject matter of the writ petition. He is will file.
No.
Not be the
So
subject matter
prima
of this
facie,
writ petition. What
prima
is it?
facie, my lord, all the
provision is
computations, prima facie, all the computations which my learned friend has shown does not even contain a whisper as to the change in market value. Subject to correction, kindly seize. 15%, 10%, that is what, page
Yes.
15. Yes. So if they want to invoke the provisions of 14A3,
I will not want to invoke.
that's what they're saying.
My learned friend wants a revision. He has written saying.
I say this determination, there's no revision. My learned friend says, no, look, it's not a determination, it's a revision. And revision under 14A3. So if my learned friend says, this is a revision under 14A3, then the mode of computation which has been annexed to their the documents, kindly sees, which is appended at pages number 60 onwards.
Revision correct or not, my lord, is subject matter
60 onwards.
different.
Does it even show that 14A3 has been looked
that
into?
Can be a very good ground in challenging in the. If you do not succeed here.
That caveat is very important.
Yes, that with that caveat.
Yes,
that caveat.
But this is what was calling from your lordship, that revision is not possible if that is not the case. It is there. And I say, my lord, every time an arbitrator cannot be appointed. And also, every time, my lord, there is no agreement, an arbitrator should be appointed also, my lord. Cannot, my lord, be the scheme. There might be a situation, there is an agreement. Most of the times, he comes to me, we don't agree. But here, my lord, he has taken the money with objection and then wants a fresh compensation. That is, my lord, also not within the scheme. If there is no agreement, we are talking no agreement, yes. He has not taken money, I have retained the money, you go for a reference. That, my lord, is 11B. No, kindly, my lord, sees the language. Determination where no agreement can be reached by the state government shall appoint the district judge. No agreement. But here, there is a compensation already done by the collector. Money has been taken, albeit not
Given.
with there. Section 8 of the Contract Act also, my lord, if we apply here, he has taken the consideration today. That
No more, this is the other way around for me.
It's without prejudice.
without prejudice.
And
without
this,
prejudice,
and
that's a different thing
not even that, my lord.
He
Not
says,
even
"I'm
that.
accepting it. To create a West Bengal premises tense.
The payment being made by them. So it's the other way around.
Please give me one.
So whatever it is revision. We are coming down to that. At this stage, my lord, arbiter is not an option. In my respectful submission.
Provision of 5% increase every 3 years. Provision of 5% increase every 3 years.
Not that. I'm looking at it. Trying to find out some logic behind this too. How fair rent and other things are revised. There also the initial fixation of fair rent is on the actual cost of construction.
Yes, that provision is here.
And the market price of the land on the date of commencement of construction.
Yes.
So that's the value which takes the initial fixation of the fair rate.
Absolutely.
Here also, you will be finding 4A3 and other things. The revision, here the revision, its mode of different statutes may vary. Here it says once it's determined, then such and such period, such and such rate and other things constructed prior to this, constructed after that. It's a different thing, commercial, residential. Here the revision is if the market price gets. So market price at something of the property also in the West Bengal premises tenancy
But
Act, also at the initial stage.
yes, but subject to correction, my lord,
So,
that fair rent fixation is, my lord, determined, and it also says every 3 years 5% increase. The statute provides that.
yes.
The statute provides that. So there's, my lord, a modicum of enhancement, my lord, which is laid down by statute. Here in this act, my lord, this is silent.
That question I will answer in the judgment.
Obviously, that is what
question which you have put. That will be my reply. Will be in the judgment.
The writing is on the wall. We've known. I can't have a choice of forum. As I said, I can't have a choice of forum. I should have, my lord, a forum to ventilate my grievances, my lord. with regard to the computation, whether it's under this act
There is fresh.
or under the aegis of the 226 code. And that I leave it to Lordship.
Awesome.
And Milord, it will perhaps not, Milord, be.
Lord, this matter
it
has a
will-
checkered history.
Milord,
And I'll tell you,
maybe.
this was one of the first briefs that I handled in 2004. For the transfer brief at that point of time. We lost before the single judge. We lost before the division bench. Into Supreme Court. Supreme Court opened again and remanded. Then it somehow transpired by that time, the time period has lapsed. So we changed our stance and we said that now the acquisition has lapsed, kindly give it back to us. Because the Supreme Court opened the entire issues.
It may not be at least fair on the part of the state, Milord, now, after 18 till now, Milord, saying you go for a fresh reference. It also, Milord, that
Go for a fresh.
reference, what my learned
Milord,
friend is
if now they have been
after
sitting,
him being
if
submitted to
Milord,
this,
they
after
were
we have
sitting
done
tight
this
of
on
the
this
property from 1989 till 2018,
that Milord,
and then it took an order
may
from
not
the
be fair.
court to Milord restore possession to 23. Milord, I don't feel it lies in the mouth of the
No,
state
no.
to say this.
Maybe I have not
Let's call
given
the
it
next
enough.
matter.
I'm grateful, Milord.
Call the appellate side. Yes. Thank you.
अरे 18 টা আসি দেখে দিন Number 18. Well, I'm for the petition.
Yes.
We will take a short pass now.
Yes.
Advocate. Agarwal is on the way. She's coming.
Yes.
We'll
Yes.
take a short
Yes,
pass.
Mr. Bose.
Oh, yes.
Yes.
Milord, as far as yesterday's case, Milord, I was going through it, Milord. Everything turns on what has been alleged on the police. Now, Milord, the instructions I have received, Milord, they say that no such request to vacate the property has yet been made by the police. Well, in teeth of that assertion, probably, Milord, the apprehension is unfounded of the petitioners. In fact, I was going through the law at the stage of, Milord, seizure or, Milord, freezing. This also does not arise. It will arise probably after, Milord, forfeiture. Handing over of possession is a stage after that.
Please show me those provisions.
Yes. My lord will kindly take up, Milord, chapter 5A.
If
Why-
you say that, I can record your submission
yes,
that till now you have not directed
Yes.
them to vacate.
Yes.
With that, I can dispose it of.
And I'll show one provision of the rules regarding taking over possession from the tenant.
My lord, if I may read out this
But
sentence.
taking over is there. He's not saying.
Yes. That has not arrived yet.
Till now, that stage has not reached.
Yes.
My lord, if I may just place this sentence from my side.
Uh,
The allegation that police authority reached that concerned
page.
bank. No, my lord, not the page. My instructions, if your lordships look at also. My lord, 1, 2, 3, 4, 5. The fifth bullet point, my lord, if you
regard.
No,
No, I will record only that part that till now he has not
No, no.
directed, he has not passed any order directing you to vacate.
Yes,
So
and
I
there
give
is no
you
such
liberty
occasion.
to approach at the appropriate time.
Yes, Milord.
Now the stage has not yet
And
reached.
Milord, and Milord,
Premature,
he is
yeah.
not contemplating also, Milord, any coercive action, Milord, as on date.
No, he has not given. So a stage has not yet reached.
Yes,
for
Milord,
that.
kindly record that.
So you have approached at a premature stage.
But
You have
record
yet
is
record that.
And my lord may also, my lord, subject to if your
Suppose
ladyship.
I cannot say he has not contemplating.
Yes.
Maybe after 7 days.
no, at present, as on date, Milord.
Yes,
Not
yes, as on date, I am
As
saying
on
that
date,
no
there
order
is no
he has
action.
served.
No,
I will
no
record.
action by the police to evict him as on date.
Yes.
And my lord, another thing, if your lordship so deems fit, my lord may kindly be, my lord, pleased to record the suggestion of the police or the communication
Milord,
of the
only one
apprehension of the
indulgence,
police.
one indulgence,
The
since
police will not take any step beyond the law. Of course not. But this, my lord, if your lordship, I leave it upon your
For
lordships.
what?
My lord, since it has come and since, my
No,
lord,
no. What recording?
my lord, this situation which can be contemplated, my lord, in the future, my lord, it will be.
That bolt part.
I leave it on your
But I
lordship.
don't think.
Very well, my
my
lord.
union
And
has shown,
and-
Milord.
I will record that you have given a copy of this. This will
Yes.
be there.
Yes, yes.
So
That will
I
be on
record
that will
you
be
have
on
given
record.
your
Very nice.
instructions to Mr. Bose.
Yes,
with
yes,
regard to
yes.
that.
Milord,
That I will record.
since Milord, I am not going beyond the pleading and the scope of the writ petition, what future will bring something for us, Milord, that is what he has said, Milord. I am not going into the question inviting this court.
Yes, because your cause of action was that
Only,
some
Milord.
verbal directions to vacate was
Yes,
there. That's
yes.
the cause of
That
action
stage,
for
yes.
which you have
So I
approached.
rest my
So,
submission.
according to him, that's
Only, Milord, record that
is
as on date, Milord, there is no contemplation. Only, Milord.
Yes,
And yes, she is on the way. I have been informed. She has been traveling, my lord. Madam Manja Agarwal. My
what
lord,
is your instruction? If I record that,
She's coming, your lordship.
she probably wants to make some submissions and she is coming, my lord. Her junior has frantically, my lord, been nudging me to inform your lordships because since she could not join online, she is now running to court.
where is she?
Lordship,
her
she
way.
is on her way. She's on her way.
From her chamber or something?
Yes, from her
From her chamber, she is on her way.
তাহলে লিখতে লিখতে তো হয়ে
হ্যাঁ।
যাবে। নামটা লিখে দিন না।
অন্য কিছু যদি বলে
Lordship.
শর্ট করা যাবে তো
probably she has got something to say about this.
Later,
Huh?
She's in the lift. She's in the
She has,
lift.
3:30.
she's in the lift, I say. I have been
leave.
in the lift.
লেখা শুরু
Then Mr. Bose, you can continue with
Yes.
something so that
No,
meantime,
Milord, I am only saying, Milord, that my junior has handed over a rule, Milord, 162 possibly, where the right of the tenancy, right of the tenants, Milord.
rule
Page 162, Milord, rule 10, 89 rules.
rule 162 of this book.
Yes, page 162. Page 162, rule 10 is an 89 rules. Page 162 of this book.
rules বলছে?
Tenancy একটা 89 rules আছে কিনা?
Yes.
Page rule 10 is there, Milord.
163. Occupation of land or building. Yes.
The right of a tenant to be adjudicated by the administrator whereas there is scope. But this point has not yet come.
This
That
number
you can
order,
advocate.
Now,
If
Milord,
there is any violation, you
Yes,
can
yes, yes.
very well challenge.
Under the law,
But till now, the cause of action, it's a premature one.
yes,
Miller also,
After recording his submission.
yes.
and also Miller, not regarding the matter, but also Miller, this why this order was given to them. The first reason your lordship has only Miller disclosed to them after my submissions. The second one is the income, Miller, the monthly rent that becomes the illegally acquired property. They must take care probably that if they keep on depositing it in the frozen account, no problem. But if some other Miller mode is adopted by them, that may not inure to
Bank
their
cannot,
benefit.
Milord, bank cannot, Milord, take a, Milord, any circuitous route, Milord.
Suppose that's one way of looking at it. You are saying yes, bank, but nobody knows what will be the
Yes.
private arrangement, if
Oh,
any.
she's here.
So you are the advisor of the bank.
Yes.
So you have to,
No, Milord,
you
Milord,
have to advise them
yes,
accordingly. Mr.
yes,
You
yes,
have to advise them
yes, yes,
accordingly.
yes.
Madam.
So I will not invite, Milord, any situation, Milord, which,
Because
Milord, causes,
this act contains very, very stringent
yes,
conditions.
yes, Milord, draconian.
I have been, Milord, having the good, Milord, opportunity to assist the learned advocate general in another matter, similar matter before Justice Ghosh. Milord, I have seen that the state takes this matter very seriously, and they go to the last possible extent in all forums, even.
No, that's, the object is a different thing. Yes.
May I make my submission, Milord? I've taken instructions from the competent authority, Milord. I've been told that order under section 60F2 only has been passed.
Yes.
It is a prohibitory order. not to transfer, alienate, create.
That's there.
Bank is not
He cannot
affected by
transfer.
that.
He cannot
He
transfer.
cannot transfer.
Only record her submission.
Yes, yes, sir, please. And I have also been instructed that the stage to pass the order under section 68U has not arisen as yet.
Same submission.
Because until unless the conviction is there, thereafter only the order for possession is being made. So that stage is, the application petition is premature.
Premature.
Nobody has called upon the bank to
I'm
vacate the
not going
premises.
to that extent also, as Mr. Bose has said, because
Mr. Kindly-
Mr. Kollol Bose, cause of action of filing the writ petition was that some verbal orders by the police authority directing him to vacate. Mr. Vivekananda Bose has taken instructions saying no, there is no,
No
verbal
such-
order, no order even.
Yes.
So I record that
And
and
her-
say that's
And her submission is.
yes, that 68U order has
Not been passed as yet.
And it
The
will be
stage
passed
has
not
not
after.
arrived.
Stage has not come, but it will
The
be passed
stage
after.
has not come as yet. That this must.
This is the post-conviction stage. Milord.
Yes. তবে দাদা ওইটা কিন্তু একটু
power to take possession.
But
Hey,
Lord, Mr. Bose should advise his clients to
That is
find
right.
out the alternative.
That is
Yes.
Yes, Mr. Bose
Same
has said.
submission.
Yes.
the written instructions contain something not in a advisory manner, but to make him aware.
Aware.
Yes.
Mr.
Yes.
Bose is there, he will advise his
Yes.
client accordingly.
This instruction may be kept on record as your lordship
Yes.
has been.
Gratefully, Lordship.
to your benefit.
এই বইটা দিয়ে দিন।
নেই my lord.
Yes, Mr. Bose, Mr. Dev,
My lord,
that is your counterpart.
you at the past sitting, my lord, he was there. Then, my lord, not today.
What is this matter?
That was a proclamation was made, my lord, against the proclamation. He has come to your lordship. The auction notice was issued, my lord, on 10/2. That is page 73.
Page
73, my lord. He challenged that e-auction notice. E2. Subsequent extension, notice being authored.
Yes, where is the learned advocate?
Previously, my lord, 71. Who notice was
71. Where is he?
71. First notice is, my lord, 13/1/2006, 26. Next, my lord, 73. 71 and 73, my lord, he challenged those.
All right, not today. Yes, not today. Yes. Yes. Mr. Mitro,
Said hopefully he will take the rest of the day.
Then even my learned friend is there.
just বলে দিন স্যার।
Order matter release.
এটা ছাড়া বলুন আবার। Yes.
My lord, on the last occasion, my lord, if I remember it correctly, the point whether, my lord, order 13A of the Civil Procedure Code as amended, or my lord, as incorporated by the Commercial Courts Act, my lord, is or can be made applicable for eviction suits like this, forfeiture. That was, my lord, your lordship's point, not my lord, but I shall try to, my lord, address your lordship on that. Now, my lord, that it appears, my lord, an identical suit was filed, my lord, in Delhi High Court. I shall rely on that judgment, and then, my lord, I shall go into the law. My lord, this is reported in 2022 SCC Online Delhi 2007. It's a division bench judgment. 2007.
It's on forfeiture. So at the time of hearing is at the time of.
I shall come to that. I shall deal with that.
Yes.
I shall deal with that.
So that has been dealt with in this
No,
judgment.
not really. Not really. But identical facts, forfeiture,
And my lord, suit on that basis.
What happened?
Lord, I am paying for one little indulgence. I have, matters 20, 22, 23, 24. Look,
Yes.
on my personal ground, I cannot come. Only take it on Monday, my lord. Let it return its position. Otherwise, I will lose everything. Already, your lordship had this matter, was about to deliver a judgment. There I
Against you or in your favor?
that I say I can say that in my favor.
What are 22, 23, 24?
Yes.
Monday a করে দিন date করে রাখুন।
I'm grateful to my lord. My lord, kindly do not take me amiss, my lord.
This week কালকে not today করে রাখুন।
Only today, yes.
তাও করতে হবে not this দেখুন যে
Hey, Dut.
yes yes
Now, my lord, copy দিলাম?
yes judgment are
Well, kindly, my lord, hurriedly may I go through it, my lord.
yes.
The appellant tenant, the original defendant before the learned trial court, hereinafter referred to as appellant, has preferred the instant appeal against the impugned judgment dated 19th February 2022, whereby the learned trial court has allowed the application under Order 13A of the Civil Procedure Code, read with Section 151 CPC, read with Section 3 of the Commercial Courts Act, filed by the respondent landlord, the original plaintiff, before the learned court, and decreed the suit in favor of the respondent. Succinctly put, the respondent instituted a suit for possession, arrears of rent along with mean profit, hereinafter referred to as a suit against the appellant inter alia, claiming the following reliefs. The reliefs are set out. Kindly turn the page. Kindly come to paragraph 3, my lord, is the lease deed. Kindly come to paragraph 4. It was during the subsistence of the aforesaid lease deed that the unfortunate outbreak and spread of COVID-19 pandemic across India caused suffering to the public, including the appellant, primarily during the then prevailing lockdown period since and from March 2020 for the ensuing months. This resulted in non-payment of rent in compliance of the lease deed by the appellant to the respondent, which in turn resulted in the respondent issuing legal notices on 20th April 2020, 11th May 2020, and 28th May 2020 to the appellant, calling upon him to pay the monthly rent as per the lease deed. All this, my lord, during, my lord, April, May.
COVID.
Ours are much subsequent. Ours are much subsequent. So much so, in one such legal notice, the respondent voluntarily offered to suspend the obligation of the appellant to pay the monthly rent for a period of 60 days with effect from 23rd March 2020 on compassionate ground. However, the appellant never responded to the aforesaid offer and thus never availed of the same, and instead chose to remain in possession of the premises till termination of the lease deed by the respondent without exercising his right to terminate the lease deed. Facing the lull from the appellant, the respondent was constrained to terminate the lease deed by issuing a termination notice dated 7 June 2020. It was then that the appellant, with its reply dated 10 June 2020, took the plea of force majeure contained in clause 14 of the lease deed and denied its liability. However, as the appellant was not relenting to comply with the mandatory provisions stipulated in the lease deed, the same led to an institution of the suit by the respondent against the appellant before the learned court. During the pendency of the suit and before framing of issues therein, the respondent filed an order 13A application pleading that in terms of clause 7 of the lease deed, the appellant was permitted to use the premises, etc. Then, my lord, paragraph 7, after completion of pleadings, it was heard. Then paragraph 8, In view thereof, the learned trial court came to conclusion that as the appellant has failed to establish any ground of defense, he has no real prospect to defend the claim of the respondent and thus allowed the order 13A application vide its impugned judgment. Then 9, my lord, being aggrieved, the appellant has challenged the impugned order. Then, my lord, the grounds kindly come to paragraph 12.
Yes.
Before delving into the factual aspects of the case and the argument addressed by the learned counsel for the appellant, this court feels that it would be in the interest of things to pin down some facts about the introduction, emergence, and purpose of Order 13A CPC. The said provision of Order 13A was introduced in the CPC by way of an amendment in the year 2015 with respect to all kinds of commercial disputes only. The said Order 13A is a provision enabling the court to take up and decide claims in the commercial disputes without recording oral evidence. That is, without following the ordinary procedure to be adopted and followed in an ordinary suit. For this, it is mandatory for all the parties involved to mandatorily follow all the stipulations contained in Order 13A CPC, whereby during the pendency of the proceeding, that is a suit, all the parties to the dispute can apply for a summary judgment at any stage after the service of the summons, but prior to framing of the issues.
Yes, that's the language of.
That's the language. So hearing, my lord, I shall also, my lord, try to demonstrate. Hearing means, my lord, at this stage. Not, my lord, the conclusion. Hearing, my lord, maybe a single judge, my lord, other courts have, my lord, defined, my lord, what is meant by hearing. I shall show your lordship that. While deciding the said application for passing a summary judgment under Order 13A, unlike the provisions of Order 12 Rule 6, there need not be an admission and it is not a precondition. Two fundamental grounds which have to be satisfied while deciding an Order 13A application are that a party has to show that the other party has no real prospect of succeeding in and defending the claim, and there is no other compelling reason as to why the claim should not be disposed of before commencement of trial, that is recording of oral evidence. In an Order 13A application, the applicant has to mandatorily contain the matters relating to a statement that firstly it is for passing of a summary judgment, and secondly it must precisely disclose all material facts and identify the points of law, if any, and thirdly, if any reliance upon a documentary evidence is placed, then it should contain and include such documentary evidence. And fourthly, further identify the relevant content thereof on which the reliance is placed upon. And fifthly, it must contain the reasons why there are no real prospect of succeeding. Then, my lord, 12.3. This is important again.
Yes.
However, upon the hearing fixed for summary judgment, the non-applicant has to be given at least 30 days notice containing all the details qua the date fixed for hearing and the claim proposed to be decided at the time of the said hearing. Thereafter, the non-applicant may, within 30 days of the receipt of notice of application of summary judgment or notice of hearing, whichever is earlier, file a reply mandatorily containing the matters, firstly disclosing all the material facts, and secondly identifying the point of law, if any, and thirdly stating the reason why the relief sought for by the applicant should not be granted, and fourthly, if any reliance upon a documentary evidence is placed, then it should contain and include such documentary evidence, and fifthly, further identifying the relevant contents thereof on which reliance is placed upon, and sixthly, stating the reasons why there are no real prospect of succeeding and defending the claim as the case may be. And seventhly, concisely stating the issues that should be framed for trial. And eighthly, identifying what further evidence shall be brought on record at trial that could not be brought on record at this stage of summary judgment. And lastly, stating why, in the light of evidence on materials or record, the application for passing a summary judgment should not be proceeded with in addition to other relevant matters. Furthermore, and if the non-applicant wishes to rely upon additional documentary evidence during the hearing, then it must file such documentary evidence and serve copies of such documentary evidence on every other party to the application at least 15 days prior to the date of hearing. Similarly, if the applicant for summary judgment wishes to rely on documentary evidence in reply to the documentary evidence by the non-applicant, the applicant must file such documentary evidence, etc. My lord, these are the procedure given. And my lord, ultimately, my lord, the appeal was dismissed. Appeal for, my lord, the suit on the ground of forfeiture for default of payment of. Now, this is, my lord, I am relying on this because, my lord, the facts are identical.
Also, this supports your argument that you said COVID-19 that does not take away his response or liability to pay off because he was in occupation. That's exactly the reasoning given in paragraph, I think 16.
Yes, I will tell you, Lordship.
Paragraph 16 was that reasoning.
16, yes. 16.
That was the reasoning.
Yes. And here also in our case, my lord, force majeure is
the last 17 last two lines willingly chose to retain the possession of the premises, and as there was no clause giving any respite to it, appellant was bound to pay the monthly charges. That was your submission of the from the first day that he has to pay.
Absolutely. Now, my lord, question was, my lord, whether, my lord, the effect of section 114. Now, my lord, lordship will kindly take up the Commercial Courts Act once, or my lord, the Civil Procedure Code once, my lord, as amended.
13A.
13A.
ওইটাতে নেই।
Yes. I kindly come to rule 1. Scope of and classes of suits to which this order applies. Lordship got it. Now kindly come to rule 3 or sub rule 3, I would say. Notwithstanding anything to the contrary, an application for summary judgment under this order shall not be made in a suit in respect of any commercial dispute that is originally filed as a summary suit under order 38, order 37. I am trying to point it out to your lordship for the simple reason that, my lord, no similar provision has been incorporated excluding suits or eviction under forfeiture.
Yes.
Now, my lord, question, my lord, which cropped up or which, my lord, was troubling your lordship, that hearing. At the hearing, if your lordship is pleased to look into, my lord, the section 114.
Transfer of Property Act.
Yes.
A Transfer of Property Act to them. থাকবে
My lord, kindly look into section 114.
Yes.
Relief against forfeiture for non-payment of rent. Where a lease of immovable property has determined by forfeiture for non-payment of rent, and the lessor sues to eject the lessee, if, kindly take note, if at the hearing of the suit, the lessee pays or tenders to the lessor the rent in arrear together with interest thereon and his full cost of the suit, or gives such security as the court may think sufficient for making such payment within 15 days, the court may, in lieu of making decree, two things. Firstly,
Discretion.
Absolutely. Now, my lord, it may come back to your lordship's mind that, my lord, on the very beginning, my lord, your lordship wanted to know whether they are willing to pay. They refused. There is nothing on record to show that, my lord, at the time of hearing, when, my lord, order 13A application was taken up for hearing, my lord, everybody knew that, my lord, it was an stage of final hearing. A suit for eviction, even if it goes into trial, when the trial commences, my lord, nobody knows, my lord, the fate of the suit. The obligation of the defendant, my lord, the tenant is, my lord, to pay the money. Similarly, my lord, when the hearing of, my lord, the application under order 13A commences, my lord, people knew that, my lord, it's for final decree. Final adjudication of the suit. There is nothing on record, and your lordship can take it from us, my lord, or that, my lord, the instruction is that, my lord, no, my lord, tender was made.
It can be at the time of hearing of the suit also.
Absolutely. Now, question is, when is the hearing? What is meant by hearing? Now, my lord, for that, I shall rely, it's a single bench judgment. I shall rely on, my lord, a judgment of, my lord, Karnataka High Court. Yes. Karnataka High Court.
So prior to that,
Yes.
have you considered the decisions on 114? What does the hearing mean?
Yes.
Because some decisions at the final hearing stage also.
I shall, my lord, no, not only final hearing. It also says that in course of, my lord, hearing of the appeal. Absolutely. So, my lord, when the hearing commences, now, my lord, the hearing commenced, my lord, of the order 13A application, there was no offer. When the hearing before your lordship, my lord, assuming, my lord, that, my lord, this 227 is a continuation of, my lord, that, like, my lord, an appeal, even before your lordship, no offer was made. It's not a question of offer, it's, my lord, payment.
Payment, undertaking, either actual payment or undertaking to pay within such and such time.
Yes.
So, has to
Same,
be.
same. Same. No, my lord, nothing has happened. And lordship has seen, my lord, they have what they have said, my lord, boldly, that, well, COVID, I shall not pay. Then I shall pay a percentage of it. It may also come back to your lordship's mind, my lord, that the lease deed, the document, the tenancy document, my lord, provides, my lord, enhancement of rent from time to time, not followed. And they are enjoying and carrying on their business from there. Now, on hearing, my lord, what does, my lord, the Karnataka High Court says, my lord, may I show your lordship only one paragraph of a judgment reported.
13A.
No, no. Simply stated hearing, what is meant by hearing? My lord, this is 2003 Supreme SCC Online Karnataka, page 424. 424.
Paragraph.
Kindly come to paragraph 17.
Yes.
17.
Yes.
Lordship got it?
Some. Yes. Language employed.
Language employed in subsection subrule 3 of Rule 14 of Order 7, feasible. And subrule 3 of Rule 1A of Order 8 also assumes significance. It was, my lord, regarding the question of disclosure of documents. The words used in the said provisions are that if the documents are not produced or entered accordingly, shall not without the leave of the court be received in evidence on his behalf at the hearing of the suit. Therefore, in order to appreciate this provision, we have to see the meaning of the word at the hearing of the suit. The word hearing has been the subject matter of interpretation in several decisions. The consensus arrived at in respect of the meaning to be attached to that word is now well settled. The expression hearing used to describe whatever takes place before a court closes the judicial functions at any stage of the proceeding subsequent to its inception. It refers to all the stages of the trial of the suit, namely the settling of issues, taking of evidence, and hearing of argument or other proceedings pending final adjudication of the suit. It may not refer to matters connected with the disposal of interlocutory proceedings in the course of suit, but it includes all proceedings which lead to the disposal or decision of the suit as such. This is, my lord, what I was trying to submit before your lordship, that when the parties went for hearing of, my lord, the Order 13A application, the parties went knowing that it is the final hearing, or it is the hearing of the suit. Nothing further was required. Then may I, my lord, not very relevant, but may I conclude it? Therefore, the phrase at the hearing of the suit employed in the aforesaid provision makes the intention of the legislature or parliament very clear. That is, after the pleadings are filed, before the judgment is pronounced, or at any stage of the proceeding, the document could be produced with the leave of the court. Therefore, the documents referred to in class 1 such and such could be produced at the hearing of the suit before the judgment is read. Commercial Courts Act requires, my lord, everything to be, all documents to be disclosed. Whatever the defense is there, my lord, that has to be disclosed. And, my lord, I have shown your lordships the affidavit in opposition also. Their stand is, no, we shall not pay.
Because of COVID.
Yes. Now, my lord, I had placed emphasis on me. Discretion. Now, my lord, I'd like to rely on two judgments, my lord. My lord, the first one is the division bench judgment of our court
So it's only one thing. Whether it's directory or mandatory, there are many decisions with whether it, in a particular case it is to be read to be a directory or mandatory.
not in the context of 114. Not in, yes.
And generally,
In general, yes.
Generally,
Yes.
when it is used.
Yes, it can be.
Now, if it is,
Yes.
the purpose of extending benefit
Yes.
to a class of persons.
Yes. Yes.
So then, how should it be?
Yes, absolutely. That is
interpreted?
what
Because that's
exactly.
the case here.
That is exactly what, my lord, I would show your lordship, my lord, what our division bench said, and thereafter, my lord, what the Supreme Court said. My lord, I shall rely on a judgment, a division bench judgment of this court reported in, my lord, 1988, volume 2, Rent Control Journal, page 239.
1988,
volume 2.
Is this journal still being continued?
I was subscribing, my lord, but I don't think that it is.
Now getting?
No.
I was also a subscriber of this journal, but this is Rent Control Journal and Rent Control Reporter.
Yes. No, I don't have the reporter, but I
had, but thereafter,
many of the journals, CWN.
CWN is. And after COVID, the other journals are now with this.
Yes, that again is a greater difficulty. And my lord, the other difficulty I will tell your lordship, my lord, I feel is a space.
Yes, that's the real difficulty. That's the real difficulty. And nowadays, the volumes of SCC,
yes,
physical volumes of SCC, there is no end to it.
I forgot to note it down. I forgot to note it down. I once found the same judgment of Supreme Court reported in 2 volumes of SCC.
Same judgment?
Same judgment. I compared, when I found it, I compared and I found the same date, same, obviously, cause title, the honorable judges and the language. Same judgment.
It has to be. The date of the judgment and the number is same.
Has to
be the same.
No, I initially thought maybe something,
yes.
some application.
Modification,
Yes.
review or any other thing.
But I forgot to note it down. May I? Two paragraphs, man. Kindly come to paragraph 5.
Yes.
As urged before us, the point for determination is whether this appeal should be disposed of granting relief to the defendant appellant against forfeiture of the lease agreement in terms as asked for by the defendant appellant. As asked for. The plaintiff respondent has seriously resisted this petition filed by the defendant appellant, asserting that in view of the acts and conduct of the defendant appellant, who is a habitual defaulter and can be said to be a recalcitrant tenant, he is not entitled to any discretionary relief against forfeiture, and there is no merit in this petition. It is now a settled principle of law, as enunciated by the Supreme Court in its decision reported in such and such. This is 1953 Supreme Court, followed by the division bench of our High Court, reported in such and such, and further decision reported in such and such, that relief against forfeiture is a matter within the discretion of the court. The conscientious opinion of such courts concerned is that in exercising the court's discretion in granting relief against forfeiture under Section 114 of the Transfer of Property Act, each case must be judged by itself. The delay, the conduct of the parties, and the difficulties to which the landlord has been put should be weighed against the tenant. No rule of equity, justice, and good conscience can be invoked in the case of a recalcitrant tenant who is a habitual defaulter. He cannot always be allowed to take advantage of his own wrong and to plead relief against forfeiture on every occasion. Then kindly come to one more paragraph, paragraph 7. Coming to the facts of the instant case, with reference...
Conditional offer.
And turned down.
Cannot be, this cannot be a conditional one. 114 cannot be a conditional offer.
Cannot be. Cannot be. হ্যাঁ বললাম May I read it out, man?
Yes.
Coming to the facts of the instant case with reference to the petition filed by the appellant, we find that the offer made by the appellant defendant is not an unconditional one. He has disputed the plaintiff respondent's right to get the arrear rent as claimed and has pleaded for set-off or adjustment in regard to sum of rupees such and such allegedly spent by him for repairing the suit premises and further claiming an exemption altogether of the periodic increment of rent of 5% for every 5 years. We have already seen that the finding of the lower court on this point is completely different, as the defendant failed to prove his case in this regard by producing any cogent or reliable evidence. In order to get the benefit of relief against forfeiture, the defendant appellant is required to pay or to tender to the lessor the rent in arrear together with interest thereon and the full cost of the suit, or to give sufficient security with undertaking to make the necessary payment within 15 days. A simple offer to pay the requisite amount within 15 days is not enough and cannot be said to be in any manner due compliance with the requirement of that section. In the instant case, the lessee resisted the suit for ejectment on false and frivolous grounds. Not only he did not pay anything within the stipulated period, he took a false plea of adjustment against the arrears of rent and municipal taxes, which was completely disbelieved by the trial court. True, the petitioner appellant deposited a sum of rupees such and such, but this was done pursuant to the order of this court as a condition for obtaining stay order in title execution case. This order, however, was passed by our court without prejudice to the rights and contentions of the decree holder and respondent.
So on the facts of that case, taking note of the conduct of that particular tenant, it was not.
And kindly look into here, my lord, the conduct. Kindly, I beseech your lordship, my lord.
It's not a matter of right, it's the discretion of the court.
And my lord, this is exactly what the Supreme Court says. One paragraph of, my lord, a subsequent judgment of Supreme Court.
On 114?
Yes. 1995 Supplementary Volume 3 Supreme Court Cases 167. এটার একটা কপি লাগবে আমি এটা পড়ে নিয়ে দিয়ে দিচ্ছি আচ্ছা আছে হ্যাঁ Only one paragraph. Well, let kindly come to paragraph 7.
Yes.
I'm not going into the facts, my lord. Paragraph 7, kindly come to. As regards the application under Section 114 of the Transfer of Property Act, it is one of the settled principles that law abhors forfeiture. However, Section 114 is a discretionary relief based on equitable consideration. Having regard to the above conduct of the tenant, the court below had justified in its conclusion. In other words, the tenant by its conduct has disentitled itself in seeking the discretionary relief of Section 114.
So
The-
conduct has to be looked into. On equitable consideration.
Absolutely. And here, my lord, as I have already said before your lordship, my lord, they are occupying, my lord, 43,000 and odd square feet on VIP Road with, my lord, 40 car parking spaces, running their business. Vishal Megamart, if one can see, not paying anything. At least not as per the obligation under the lease deed.
They're not paying anything, or they're paying at the reduced rate now?
Yes, reduced rate.
Reduced rate.
Not
they're
as per
paying.
the agreement.
As per the lease deed. Yes.
They are depositing rightly, we are not and if they are unilaterally doing it,
They are going on depositing in our account.
No, depositing not as per the lease deed.
No, no, no.
Not as per the
No,
date
no.
of the lease deed. Anything more?
My lord, what? No, no, ওটাই দেখিয়ে দিচ্ছি. Only thing is, my lord, as I have submitted before your lordship, that my lord, order 13A specifically excludes a particular type of suit. Suit originally filed under chapter 37.
According to you, this forfeiture suit, eviction suit on the ground of forfeiture is
Or
not excluded.
no exclusion. Now, my lord, on this, my lord, may I rely on a judgment of Delhi High Court, my lord, reported in 2017 SCC Online Delhi.
At what point?
That, my lord, it has to be specifically excluded. If, my lord, the legislature wants something to be excluded, it has to be specifically done.
Yes.
It's not required to be included.
No, no, no. Everything is included. If
Everything
it
is
falls within
included.
that commercial dispute and other things, then everything is included. If that is included, unless it's expressly excluded, everything comes within that. I'm not on that. I'm not saying that an eviction suit on the ground of forfeiture is not included, but only I was thinking in that line that hearing would be at that
Hearing.
stage.
Now, my lord, as I have submitted, my lord, when the parties went for hearing of, my lord, the order 13A application, my lord, the parties knew. The parties, I'm definite the parties did not know the ultimate result of that application. The parties knew that they were going for final hearing of the disputes. And that
Yes. You are trying to show some judgment.
Yes, my lord.
That unless it's expressly excluded.
Yes. এটা দেখুন না, সুপ্রিম কোর্টটা দিয়ে দেবে। আচ্ছা ঠিক আছে। My lord, this is, my lord, reported in 2017 SCC Online Delhi 6394. না ঠিক আছে। কালকে
Yes.
Kindly give me a minute's time. Well, let kindly once come to paragraph.
Starts with a quotation from Alice in Wonderland. Yes.
Now kindly come to, since your lordship on the first is on the first page, my lord, kindly come to paragraph 3. It was a suit, my lord, on infringement of trademark. Then kindly come to, my lord, paragraph.
It's a commercial suit.
Yes. Paragraph 7, my lord, it deals with, my lord, order 13A. It sets out the provisions of order 13A. Then kindly come to paragraph 11.
Paragraph
11.
Yes.
This submission, it is basically, on the other hand, the learned counsel for the respondent, and in particular the respondent number 1, submitted that the court had jurisdiction to issue a summary judgment against the plaintiff in view of the provisions of Rule 3 of Order 13A. It was submitted that the power of a court to pass a summary judgment in a commercial matter is quite distinct from the procedure to be adopted invoked by the parties to the suit to seek a summary judgment. It was contended that The provisions of Order 13A Rule 3 of the CPC vest the court with wide power, and the mechanism for invoking such power which has been provided to a party under Rule 2 could not be treated as a condition precedent to the exercise of the power. It was also submitted that a provision has to be interpreted in such a manner that every procedure is to be regarded as permitted to the court
unless expressly prohibited.
It is expressly prohibited, but this is submission in this context. My lord, kindly come to 2011 volume 2 Supreme Court cases 705. I shall show that.
Yes.
Kindly come to paragraph 2. This appeal by by special leave has been filed against the impugned judgment of the High Court of Allahabad. It appears that the appellant was a plaintiff in suit number such and such before the court in civil Varanasi. He filed an application to withdraw the said suit, etc. Then, my lord, kindly come to paragraph 4. We do not agree. Rules of procedure are handmaids of justice. Section 151 of the Code of Civil Procedure gives inherent power to the court to do justice. That provision has to be interpreted to mean that every procedure is permitted to the court for doing justice unless expressly prohibited.
Yes.
There is no express bar in filing an application for withdrawal of the withdrawal application. Yes.
Paragraph 5, it has been also clarified.
Yes, yes.
The quotation from that judgment.
Yes.
From ILR 1883.
Gotcha.
Prohibition cannot be presumed. That's the.
Prohibition cannot be presumed. And my lord, then my lord, of this Delhi judgment, my lord, kindly come to
The previous judgment which you relied upon.
Yes, the Delhi High Court.
Yes.
20. Yes, 21, my lord, kindly come to, in our view, kindly come to, my lord, about 8 lines from the bottom of paragraph 21, sentence starting with but in our view.
But in our view.
But in our view, this power can only be exercised upon an application at any date only after the summons have been served on the defendant and not after the court has framed issues in the suit. In other words, Order 13A Rule 2 makes a clear stipulation with regard to the stage for application.
That language is clear.
Then,
After service of summons prior to framing of issues. Within that period, you have to apply something.
Absolutely. 22 also again the same.
Yes.
No, 23 kindly come to my lord once. Rule 4, Subrule 2 of the Order 13A also requires that where a hearing for summary judgment is fixed, the respondent must be given at least 30 days notice of the date fixed for the hearing and the claim that is proposed to be decided by the court at such hearing. At the hearing, my lord. This is why I am relying on this. This is what, my lord, hearing contemplates. Rule 4.3 of the Order 13A makes provision which enables the respondent to file a reply within the stipulated time addressing the matters set forth in clause A to F of the said subrule. In particular, the reply of the respondent ought to precisely...
According to you, the expression at the hearing used in 114
yes, also applies here.
In a commercial suit shall mean hearing of summary judgment.
Of the summary judgment also. Only reason is, my lord, as I have submitted before your lordship, when we go for hearing, we know that anything can happen.
And here section 114 is only to enable
to give a
tenant to make good the arrears. That's the object, and if he makes good the arrears, he will not suffer a decree for eviction.
And a bona fide tenant, I would say.
Yes.
That is what, my lord, the division bench has, my lord, hit.
Yes, conduct is to be looked into. So that really enables a tenant or a defaulting tenant, say, to make good the arrears. So
along with interest and cost.
So by taking the aid of saying that yes, not in a summary suit, go in a regular suit, let it be proceeded for 5 years. At the time of after 5 years, after closing of witness action, I may choose to come up and pay.
Again, order 13A.
Yes.
If your lordship is pleased to look into, my lord, rule 5, rule 6.
Yes.
On an application made under this order, the court may make such orders that it may deem fit in its discretion, including the following: A, the judgment on the claim.
Yes.
Can dispose of, or the suit can be disposed of.
Yes. Judgment on the claim, conditional order,
all.
Everything.
Everything.
So judgment on the claim will be if the court finds that he has no defense.
The 2
or
points.
the plaintiff do not have any.
The 2 points.
Yes.
The 2 points.
Striking out the pleadings, further directions, dismissing to proceed for case management. That is if it fails.
Yes, if it fails.
Yes. Anything more?
Okay. Only other judgment I would like to rely on is reported in 2011, Volume 4, Supreme Court Cases 266.
2011,
Volume 4, Supreme Court Cases, page 266.
On what point?
On, my lord, interpretation of the statutory provision.
Yes. Which paragraph? May, how may is to be interpreted? Paragraph?
Paragraph 8 onwards, my lord. In Hiralal, this court observed, in construing a statutory provision, the first and the foremost rule of construction is the literary construction. All that the court has to see at the very outset is what does that provision say. If the provision is unambiguous and if from that provision the legislative intent is clear, the court need not call into aid the other rules of construction of statute. And the other rules of construction of statute are called into aid only when the legislative intent is not clear. It may be mentioned in this connection that the first and foremost principle of interpretation of a statute is, in every system of interpretation, is the literal rule of interpretation. The other rules of interpretation, example, the mischief rule, purposive interpretation, etc., can only be resorted to.
The base rule is the literal, so that is to be.
That is exactly, my lord, what I have submitted. Kindly look into, my lord, order 13A. There is no ambiguity there. Whatever was required to be omitted, my lord, that has been done in subrule 3. Rule 1, subrule 3. Suit filed under order 37 cannot be. My lord, yes. Only one paragraph from my lord.
Yes. From the plaint?
No, the application, my lord. I have placed it before your lordship. Only one paragraph. Kindly come to page 60.
Yes.
Paragraph 21 at the bottom. Your petitioner states that on service of the writ of summons, the defendant respondent had entered appearance and filed its written statement. However, the issue in respect of this suit has not been framed.
So this to bring it within that.
Yes. And it's, my lord, the page 162, their affidavit in opposition.
I don't think that is disputed.
No,
The court has not rejected on that ground.
No.
Court had rejected on the other grounds, not on the ground that.
Not on any of the grounds mentioned in my lord order 30.
Anything more?
No, those are my respectful submissions.
Yes. How much time we will take?
Half an hour, 40 minutes.
Half an hour, 40 minutes. When can you come back?
Anything you lost. Any day you lost.
Any day.
You lost may fix a day.
Only that the next week.
Anything close by, because my lord, I also tend to forget.
That's the difficult because.
And my lord, your lordship has to deal with so many matters.
কবে কিরম কি ফাঁকা আছে জাজমেন্ট গুলো একটা ইয়েতে ফাইলে করে
I would